Starts to make your way over there. What if any? When you arrive on scene, what is sort of the first thing?
So we went to evaluate the patient.
Oh shit! Did
I believe someone had started CPR prior to us getting there.
Oh my god!
So we went to
Hi guys.
When you say someone had started CPR,
I did that.
I don't remember the particular individual that was doing it.
It literally just clicked on this court session. Damn you, StreamYard. All right, guys. So you know what? It didn't go live. But you started it. So has it been recording or not? Parallax? Do I need to restart it, or are we good right now? Do I need to rewind real quick? Please tell me. It's been recording. You just start. Okay, so we need to go back. All right. All right, guys. Sorry about that. We're going to get back. This is the lieutenant paramedic, okay? So we're only a couple minutes behind. We'll catch up. There were no problems on the jury view.
Thank you, Ron. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name?
Greg Woodbury, Woodbury.
And what do you do for work, sir?
Lieutenant paramedic on the Canton Fire Department.
And how long have you been a member of the Canton Fire Department?
About 24 years
Sorry
now.
about that, everybody.
How long have you had the rank of lieutenant within the Canton Fire Department?
That's been 8 years now.
Now, prior to working with Canton Fire Department, what, if any, other work do you have within that same sort of field?
Prior to being on Canton Fire, I was an EMT paramedic in the North Shore area.
And if you could just, with regard to your working as a paramedic and a firefighter, specifically as far as being a paramedic, what, if any, sort of specialized training did you receive in regard to, or certifications did you receive in regard to being a paramedic?
So after I got my EMT, when I went to paramedic school, I went to Northeastern University. It was a 1-year full-time program.
And following, you successfully completed that program, is that correct?
Yes.
And is there any sort of continuing educational component or recertification component in regard to your paramedic certification?
Yeah, every 2 years, paramedics have to recertify. We're required to get so many hours of continuing education to recertify every 2 years.
If I could turn your attention to the date of January 28th, 2022 into January 29th, 2022. Were you working with the Canton Fire Department on that day?
Yes.
And what kind of shift were you working on that occasion?
It was a 24-hour shift.
A 24-hour shift within the Canton Fire Department is what?
It's 8 a.m. to 8 a.m. the next day.
Now, turning your attention to the 29th, at what point do you sort of get up and start to begin your day at the fire station?
So a normal day,
we're going to see at 1.5 times.
Beginning of the shift? You're talking about the end of the shift? Okay, so the second part of the shift. Normally we get up at 6 for the officers, but I got up a little earlier then because we had the snowstorm coming in. So I had to make sure everything's shoveled. I think I got up about maybe 5, check the apron of the area in front of the station, and make sure the walkways were clear.
And when you got up to check that, what kind of thing did you?
It had been snowing. There was blizzard type conditions coming in. So it was a decent level of snowfall there. Let's see, maybe 2-3 inches on the ground at that time.
And as far as with reference to that, what, if anything, did you do to?
I think we can move quickly through this part of it. The cleaning the apron.
Okay.
As far as that particular date of that shift, how were you assigned within the firehouse?
I was lieutenant on engine 4.
And with respect to that, at some point shortly after 6 a.m., did you receive dispatch to a call?
Yes. Yeah, we're dispatched to a call for a person in the snow.
And did you respond to that call, sir?
Yes, I did.
And you were assigned to the engine, is that correct?
Correct.
Who, if anyone else, was assigned to the engine that day?
So we had Kate McLaughlin and Frank Walsh were my 2 engine crew.
And in addition to yourself and your engine, what, if any, other sort of vehicles or apparatuses?
Ambulance 1 also responded with us. So that was Tony Flamati, Matt Kelly, and Tim Nuttall had also hopped on the ambulance. He was coming in the shift in the morning, came in early to beat the storm.
And you recall where the call was in regard to what the address was?
I don't remember the address offhand, but it was not that far away in the district.
And when you arrived in the engine, when you first arrived on scene, as you were arriving on scene, what, if anything, did you sort of see as upon your arrival?
So the police were already there. We were approaching the scene. I could see several people off to the side in the yard doing something, so we went to investigate that.
Say off to the side, was that to your left, your right, or something?
So the way I was approaching the street, it was on the left-hand side.
And when you indicate you see some group of people, is that correct?
Yeah, there was a few people around. I don't remember exactly how many and what they were doing.
And when you start to make your way over there, when you arrive on scene, what is sort of the first thing?
So we went to evaluate the patient. So, I believe someone had started CPR prior to us getting there. So we went to continue that.
When you say someone had started CPR prior to you?
I don't remember the particular individual that was doing it as we arrived.
My only question, sir, so it's someone outside of your department, correct?
Yeah.
And you know if it was one of the police officers or someone else?
I don't remember.
Now, obviously, you're dispatching responsive when unresponsive mail, correct?
Yes.
And at the time that you're arriving on scene, so you see that sort of cluster of people, were you able to see that unresponsive mail at that point?
Not in the vehicle, not until I exited the vehicle.
And at some point, much later or subsequently, did you come to learn the identity of the unresponsive mail of the patient that you were involved in?
Afterwards, they told me yes. At the time, I did not know.
And what did you learn his name to be subsequent?
I'm sorry, I'm a little nervous and blanking right now.
Was it Mr. John O'Keefe?
Yes, correct.
And when you first came over to where Mr. O'Keefe was on the ground, is that correct?
Yeah,
Yes,
that's
it
all they have going on at 6 in the morning.
He was lying supine on the ground, like on his back. He was parallel to the street, about 8 feet away from the snowbank.
And in reference to that, as far as the snow was concerned, what if any snow did you observe on or around where?
He was covered with snow, and there was snow around the area.
And so from a treatment of Mr. O'Keefe as a patient, what is sort of the first thing that you did or
We started CPR, or CCR, sorry, immediately. Someone went to go get a board to get him onto that, so we can get him onto the stretcher and move him to the ambulance. And then someone else was trying to get the backstory, trying to figure out the scenario that we're dealing with.
If I could just stop you for a moment. So
Yeah.
you mentioned CCR, is that correct?
Yeah.
Okay. So what is the difference between CCR versus CPR?
CPR is called cardiopulmonary resuscitation. So that is when you're helping someone breathe. CCR is when we first get to a scene, they changed the protocols a little while ago. So we don't have to give respirations right away. We can just do compressions. It's a little more effective to get the blood flowing quickly.
Thanks. As far as your involvement in patient care, sort of what was that during that initial phase where Mr. O'Keefe was supine on the ground? What was your involvement in patient care at that point?
I was assisting with the CPR, making sure everyone else was doing their test. As a lieutenant, I kind of got to manage the other people and make sure everyone's on target for what they're supposed to be doing.
And during that initial time that you're outside in the area where Mr. O'Keefe is on the ground, what if any observations you make as far as injuries to Mr. O'Keefe's head?
Outside on the ground, he was covered in snow. So we're really not doing any sort of secondary survey initially. The primary concern is the primary survey, which is airway, breathing, circulation. He was not breathing. He had no pulse. So our primary concern is to get that going.
And at some point, are you able to get him from the ground to the back of the ambulance?
Yeah, we moved him onto a longboard, then moved him from the longboard onto the stretcher, and brought the stretcher over the ambulance and loaded him in there.
You mentioned at some points upon your sort of initial arrival at the patient that different people were tasked with different things, right?
Yes.
And someone was tasked with trying to get sort of what you termed the backstory, is that correct?
Yes.
Why is that important?
So when you have someone unconscious, unresponsive, you want to know when they were last well, the last breathing, last seen, trying to figure out why someone is on the ground. There are different reasons of why they could be there, trying to figure that out. Normal people don't lay down in the snow. So trying to evaluate the reason the person was unconscious.
And so you're able to get him on, Mr. O'Keefe, onto a stretcher into the back of the ambulance, correct?
Yes,
Fair to say that the lighting in the back of the ambulance is better than it was outside.
correct.
And when you're in the back of the ambulance, are you able to then do or participate in that secondary survey?
Yeah, we started doing a secondary survey after we started getting good compressions going. Someone's working on intubation. And then one of the procedures is to strip off the clothes and evaluate the person.
And if you recall, how were the clothes removed?
I don't recall exactly which method they used. Typically, we cut them off, but I'm not sure if they did that or they just pulled them off.
And what, if anything, do you recall as to Mr. O'Keefe's clothing and sort of what he was wearing when he was found?
I really wasn't paying attention to it. The primary concern is trying to revive him.
So to that secondary survey, as far as once you're in the back of the ambulance, what, if anything, did you observe as far as injuries on Mr. O'Keefe's head?
He had a hematoma, or a bruising. The right eye was very prominent. There was some scratches on the right forearm. Was most of the external injuries we noted.
And now, in addition, so as far as people on scene, there were a number of different firefighters from your
Yes.
department. You mentioned that the police were on scene when you arrived. Is that correct?
Correct.
So beyond the police and fire, what, if any, other individuals did you observe at some point when you were on scene?
There were some other civilians there. I really wasn't paying attention to them.
Now, with reference to that backstory that you were talking about, at any point in time, either outside of the ambulance or inside of the ambulance, who, if anyone, was tasked by you or anyone else to try to obtain that backstory?
I think Katie McLaughlin was the one that obtained the backstory.
And if you know, was there any other conversation that you were present for between any of your other firefighters and any of those civilians?
That was primarily when she relayed to us the information that she had obtained. We were trying to figure out the scenario of why he was found unconscious, unresponsive.
Let me ask you this way. So as far as arrival at the patient when he's on the ground,
Yep.
Who gets there first? You and the other individuals in the engine or the firefighters in the engine?
We both responded from the same station at the same time. The engine's in the front, the ambulance usually in the rear. So I believe we pulled over, the ambulance pulled over at the same time as us. I believe C5 went as well, which is the captain. He was also responding with us.
Now, as far as the person that Firefighter McLaughlin spoke to, what, if anything, did you know about that person at that time?
At that time, I knew nothing. I knew there was someone that had been with him. She relayed the information of what she had heard to us.
And the information that firefighter McLaughlin, without reference to what it was, but the information that firefighter McLaughlin was able to obtain, did she communicate that to you and the other firefighters? In the
Yes, yes, she came in the ambulance, told us what she had heard.
As far as the information that firefighter McLaughlin provided, did that comport with what you were observing as far as injuries to Mr. O'Keefe?
Objection.
Sustained. Can lay a foundation.
Now, as far as, again, the injuries that you observed to Mr. O'Keefe in the back of the ambulance were what?
It was the bruising of the right eye and the scratches on the forearm.
And what, if anything, did firefighter McLaughlin indicate to you with and told her?
That someone said she had hit him, and he was last seen. Objection.
Sustained. That will be stricken.
May we put them?
Okay.
All right, guys. So hold on. Did Clyde skip again? No. Now, I did want to bring this up. Some of you guys were wondering, like, how far, what. Well, actually, Ghazni, Unhung Hero first. We'll start off. I'm going to come again. Ghazi still made sense. Was it snowing? Yeah, it was like a fucking blizzard. It was snowing like a mofo. Did they send the whole fire department? Yeah, that's probably the biggest. It's like 6 o'clock in the morning on a Saturday. This is the biggest thing they had going on. And Luke says, why do we need to dispatch an entire fucking fire department for one guy in the snow? There was literally nothing else going on that day. Like that's part of the issue. January 29th of 2022, January 29th was a Saturday. It's Saturday morning. There's literally nothing else. And also, for those of you guys wondering, there was a jury view, real quick, and from Fairview to the courthouse, it is, I don't know if they took this route or they went down I-95, but it's only like 8 miles away from Fairview to the Dedham courthouse. And if you guys are noticing from the street view, this is the street view. We're really wait. Are you serious? Like we did what? Like 15 minutes of. They did this for 20 minutes. Now they're going on break. What dickhead?
Hey there, Karen Reed trial watchers. You know a lot of the trials we cover remind me. It's that you got to be
assholes. That was completely asshole-ish, Judge. Fuck. Why would you do that, Judge? Why would you do that, Judge? I don't get the point. Oh. Really, this is entirely stupid. AK, a new member. Thank you for your support. I appreciate it. Thank you very, very much. The judge had shit. Yeah. Like, why didn't they just go? Judge had to piss me off. I bet she did. And if you guys don't know, the judge's name is hold on, what is it? Beverly Canone. Yeah, her name ends with a vowel, so that tells you a lot there. Toggle says, I have no peen and I must scream. At what point does this become cumulative? Well, remember, they're trying to say all the times, all the different people. I think he's going to say all the different people who heard Karen say, oh, I did it, I hit him, I did it. So, who knows? Not sure. Yeah, everybody went to the call, guys. It was, like I said, it was 6 o'clock in the morning on a Saturday. So why would they, what else are they going to do? Time to give time for chats in the hallway. The judge seceded. Yeah, she did. Well, the one thing we could say for sure, definitely, this is not a defamation case. This is not a defamation case, chat. Good news. Good news. Not a defamation case. Most judges seem to be unlikable. This one seems to be hateable. Oh, you, not Biscuit. This is far from it. This judge is not that. Trust me. This judge ain't that bad. We've had some bad judges on here before, and I've dealt with bad judges in real life. She is not a bad judge. Not at all. Not at all. The judge Richard Allen's dealing with now, that's a bad judge. That's a bad judge. I'm about 3 minutes behind in chat. No, I'm right here. This judge need to change out a fresh vodka soaked tampon. Women have done that before. I've heard of it. Yes. How about that Cincinnati judge that got disbarred and locked up? Oh, Tracy. Yeah, the funny thing is I know Nate showed that, but that's like old news out here. That's been a couple of years ago. She tried to get back in to get her license, and she got state of Supreme Court was like, nope. And yeah, it was very funny what happened to her. You guys want to watch it, we can. We can definitely do it if you want to. But it's entirely your call. So let's see if we can find that. And in my anger for long crime, I accidentally cancel it out the tab. I was a little, like I said, a little frustrated there with their just playing with our emote. Like, well, not really with the long crime's fault, the judge's fault, but I made long crime pay for it. So I don't feel too bad about that because I don't feel bad for long crime. After all, what they did to me a long time ago, copy struck me, and it was just so. All right, let's see what we can find here. The judge is edging you. Has Clyde got any more rambles? No, he's not gone on a walkabout. Who's a better litigant, Daryl Brooks or Ricada? I'd probably rather have Daryl Brooks as a client. I'd rather have Daryl Brooks as a client. So. Yeah, we can watch the judge getting sentenced. It's absolutely fucking hilarious, this judge. You guys have never heard about it. Hold on, here we go. We'll watch it for a second. Like I said, it was really funny when it happened. All right. Okay. Judge Tracy Hunter sentencing. So this is a judge from down in Cincinnati, and she had a history of causing problems, and her ultimate issue was she was a juvenile judge down in Cincinnati, Ohio. And after that, So she had started getting involved in, there were some issues with things were being signed, and as far as things were being made available for computer contracts in juvenile court, because judges are generally have a lot of authority to spend money to take care of their court the way they see fit. So she got charged with a couple of counts of evidence tampering, forgery. There were a lot of issues with um, what she had done. She'd also was considered that there was an unlawful interest in a public contract. She got charged with theft in office and misusing a credit card from the court. So like a county credit card. She got charged with a lot of things. So she's had a long history of that, and she had a sentencing, and let me see here. Yes, Brooks shows up. Well, he was forced to show up. So that's the story of Hamilton County. Yes. Yeah, so we're gonna watch this. Nate has a video on it. Apparently, he's killing it with those style videos lately. Yeah, and that's the thing, though. Like, I wouldn't have thought to cover this because when you watch it, there's a couple. Like, that's why I need to start getting back on these. Like, not just doing lives, but pre-produced stuff. But here's the thing with Tracy Hunter. Check this out, chat. This happened 4 years ago. But I have no problem going back in time. I'm just like, well, okay, we'll cover it. So yeah, no, I'm not. I think it's awesome. Nate's making it work. I was just like, what the heck? So here we go. Here we go. So here's Tracy Hunter showing up to court. With her attorneys.
Good morning, everyone.
And I will say, if you guys aren't aware, the courthouse down in Hamilton County, it's fucking massive and it's beautiful. It's an old school courthouse.
Please be seated. Thank you all very much for your patience. Good morning to all of you. For the record, State of Ohio versus Tracy Hunter, case number B1400110. This matter is on the docket today solely for the execution of the sentence imposed by my predecessor, Judge Nadel, on December 5th, 2014, for a jury conviction against Ms. Hunter on count 6 of the indictment, having an unlawful interest in a public contract, a felony of the 4th degree. The judgment entry imposing that sentence is signed by Judge Nadel and is part of the record. Mr. Singleton, Ms. Branch, you represent Ms. Hunter.
And I forgot to mention this. So in 2014, she was sentenced, okay? That's what happened there, all right? The judge sentenced her to 6 months in jail. Her attorneys filed a lot of motions and did a lot of motion practice and basically paper terrorism to the court. And she remained free, exhausting her appeals until 2019. So she appealed this all the way up to the Supreme Court of Ohio, and it took until 2019 for her to deal with the court. So that is what happened there. She also had to pay court costs and restitution. It was like $34,000. There was a lot of stuff there. So that's why you hear this judge talking about the predecessor, because it happened 5 years ago. So it's a prior judge, and the prior judge aged out and couldn't run again. So Judge Dinklacker is handling the sentence now.
Is that correct?
That's right, Chuck. Good morning.
Yes, thank you. And Mr. Crosswell, you're here on behalf of the state, is that correct?
I am, Your Honor.
All right, thank you. Thank you all for being here. I will point out, as most people here know, this is not a sentencing hearing. It is not a resentencing hearing. The sentence has already been imposed by Judge Nadel on December 5th, 2014. My job is solely to follow the law, abide by the rule of law, and execute the imposed sentence. But before we get to that, there are two things. First of all, I have in my hand a letter, which I've not shared with counsel because obviously everything needs to be on the record. It was hand delivered to me moments ago from the Hamilton County Prosecutor, Joe Dieters. I will read it for the record. Dear Honorable Patrick Dinkelhofer, you and I have known each other professionally and personally for almost 40 years. Today you are going to impose the sentence Judge Norbert Nadel gave former Judge Tracy Hunter after she was indicted by a grand jury, convicted by a petit jury, and upheld by every court in Ohio. It was also reviewed by the Federal District Court and the Sixth Circuit Court of Appeals and upheld. She has not once shown remorse. She has been incredibly disrespectful to you and to the justice system. She has in the face the fact that my office removed itself in any way from her prosecution, blamed us for her plight. That being said, I believe she has some type of mental condition that has created this scenario. Although we are not the prosecutors in this particular case, I ask as a friend of the court to consider an evaluation of her prior to imposing Judge Nadel's sentence. I have nothing but the greatest respect for you as a judge and more importantly as a person. I know in my heart that you will do what you believe is just. I've known you too long to believe otherwise. But she has basically lost everything professionally. A review of her stability to serve jail time hurts no one and may in some way aid in your decision to impose the sentence. Signed by Joseph T. Dieters. Any comment on that, Mr. Crosswell, first of all, sir?
Your Honor, I would endorse those comments.
Thank you, sir. Mr. Singleton?
Oh, yes, I want to be heard on this. Judge, I can't believe that Joe Dieters would ask for her to be evaluated. In the letter, there's reference to her not showing remorse. Here's why there's not remorse.
First of all, Mr. Singleton, with all due respect, I'll certainly give you a chance to say anything you'd like. I'm just talking about whether or not you believe this is something appropriate for me to do.
No,
Okay.
absolutely not.
I appreciate that.
Absolutely not. And if I could just say more, I'd like to. The reason I say absolutely not is, first of all, both Jennifer Branch and I have worked very closely with Judge Hunter. There is no issue whatsoever, not in the slightest, about her not being competent or understanding what's going on. Absolutely nothing. She has been very helpful to us as we have litigated her case up to the Ohio Supreme Court and in federal habeas. So that's number one. Number two, with regard to the issue in Prosecutor Dieters' letter about remorse, the reason why there's not remorse is because she didn't violate this statute. I know that there's a conviction. I understand what the courts have said about it, but under the plain language of this statute, she is not guilty of securing the authorization of employment, period. And we plan to file a motion to dismiss. I would ask the court not to impose sentence today to give us a chance to do that. I would ask alternatively that the court not impose or execute the sentence today because we are still on appeal of the habeas denial in federal court. And we would ask the court to stay execution of sentence until we finally resolve that issue. This case is, as you know, has been pending for quite some time, and Judge Hunter has been out the entire time that the appeals have run and the habeas have run. And let me just say a word about what she's gone through, because I think that gets lost sight of. Every day for the past 5 years almost, Judge Hunter has gotten up each morning not knowing whether that was going to be the day that she was going to have to go to jail.
Yeah, guess what happens to most people? That's how it goes, homie. Listen, brah. That's how it goes, man. That's how it goes. Yes, this guy's very, very short. Yes, she was already found guilty. So, yes. She's not a judge no more. She hasn't been a judge for years. So, I like this guy better in the FX show with the OJ trial. Yes. That's how it goes for everybody on an appeal bond.
I know by talking with her, by observing her.
And guys, when you heard the judge say execution of sentence, literally the sentence has been imposed. The appeals have been rejected. So all that's left is for him to tell her go to jail for 6 months. That's all that's left. So literally she's walked to the end of the plank. There's nothing left to do except shove her off. And she's still fighting.
The impact that has had on her life. We believe it would be profoundly unjust and unfair and a waste of taxpayer dollars to incarcerate her for 1 minute in the jail. We believe it would be profoundly unfair and unjust and a waste of taxpayer resources to put her on probation. What we'd ask the court to do is just end this today, but not incarcerate her, particularly given that we're going to be filing this motion to dismiss. We'd ask the court for a continuance for us to be able to address that.
May not like this. This is him doing his job. He's doing his job to say, Judge, we want more time.
Your Honor, if I might,
I'm sorry, Mr. Crosso. Ms. Branson, do you want to say anything in regards to
We'll
Mr.
talk about
Peters'
this in a
letter?
second.
Your Honor, everything that Mr. Singleton just said is true. Tracy Hunter does not have any mental condition, does not need an evaluation.
I appreciate that. Thank you. Mr. Crosswell?
Your Honor, if I might, simply in response to the letter, Mr. Singleton indicated that he did not believe, or that he did believe that Ms. Hunter was competent to stand trial. I would agree with that. I don't believe that Mr. Dieter's letter is speaking to the issue of whether she was competent to stand trial or whether she was.
Fleck, Karen Reed's on lunch break. So it's not like, yes, we're going to go back when Karen Reed comes back, but there's nothing to talk about right now. The court is back. Oh, it's not. Karen Reed's on lunch break. I hope, so we'll come back to it. Yes. Yep. We'll be back. So she was convicted of forgery. Well, and ended up being misuse of government contracts. But she had done backdated court filings. She had done forgery. She was taking interest in government contracts, being generally corrupt. MILF Milker. This is Judge Tracy Hunter out of Cincinnati, Ohio. She had she got convicted of basically fucking with the records in her court to try to cover up that she was like stealing money. She was convicted and sentenced to 6 months in jail. She appealed it for 5 years. And then finally in 2019, her sentence was imposed. And this is the imposition of her sentence. And it's actually very funny because it's like 30-some minutes, but it's rather humorous what happens. So I'm not going to spoil it. Here we go.
Legally insane for purpose of the trial. No one has raised that issue and it's not even been considered. I believe that the letter that Mr. Dieters has written and that when you asked, endorsed was a letter which asked to have an evaluation for the purpose of sentencing. And I would say that that has nothing to do with the competency issue, and it is rather, it is not uncommon for the courts in trying to determine an appropriate judgment to order a pre-sentence investigation and to order, in addition to that, a clinic evaluation to determine if there are any services that are needed or if there are any issues that present themselves. So that certainly it's up to the court, but that part of the letter that Mr. Dieters wrote is the part that I endorse, and I think it was solely for the purpose of sentencing, not to question competency in this case.
I appreciate that. And since defense counsel has indicated that they do not wish for me to proceed in that manner, I will certainly not do that. I do appreciate the concerns Mr. Dieter has extended, but that is something that we're not going to proceed with. The other thing I do need to do before we get to the other aspect of this case is I thought about this for a long time. On behalf of the justice system, preservation of the independence of the judiciary in the spirit of transparency and to comply with the dictates of Ohio Code of Judicial Conduct, I'm going to state the following. In no way, shape, or form is this to be held in any way against Ms. Hunter, but I want to point out for the last several weeks, I have received at my home, not here in the courthouse, at my home, 45 postcards from people, some of them signed, a few, some of them with return addresses, a few, but most of them anonymous. So when my wife got the mail, she looks at them, of course.
That's never a good idea, chat.
Concerned. I'm not going to read them all, obviously, but again, in complying with what I think is law, and so no other judge should go through what I've gone through with these Facebook postings by certain people and whatever, okay? I'm just going to put a couple of these on the record. 7 of them start off with, I'm a registered voter, okay? What is that supposed to mean? Well, whatever. I'm a registered voter and I believe all charges should be dropped against Judge Tracy Hunter. I'm a registered voter who stands and support Judge Tracy Hunter. Drop all charges against Ms. Hunter and exonerate her now. Dear Judge Nicklocker, please exonerate Judge Hunter of the charge she was falsely accused of. I'm a registered voter in Hamilton County. Judge Nicklocker, exonerate Judge Hunter now. Drop all charges, restore her good name. I am a taxpayer and a registered voter. I'm a registered voter. Please let Tracy Hunter. She is innocent of all charges. As a concerned citizen and a registered voter, I urge you to exonerate Judge Tracy Hunter now. I'm a registered voter in Ohio. I'm asking that you release Tracy Hunter of all charges. Exonerate Judge Tracy Hunter now. Judge Nicklocker, Judge Tracy Hunter needs to be exonerated now. Do not delay. Cincinnati needs her to be restored right away. Hello, Judge Nicklocker. I'm asking you to exonerate the Honorable Tracy Hunter from all charges at this time. If you're not able to see that she has suffered enough, I don't understand the reasoning for the time that this issue has taken. You are crucify her for making laws fair for all. Exonerate Honorable Judge Tracy Hunter. Free Judge Tracy Hunter. Would you like to be the judge that goes down in history trying to destroy someone who is doing the right thing, who is elected to serve public, especially juvenile court? Exonerate now. In the midst of this turmoil,
We're killing some time watching a funny.
Towards Judge Hunter, it is hoped that you who are
We're killing time watching a judge being sentenced to jail.
Exonerate this lady. The city is going to change according to the jail outcome. Dear sir, I do not know your religious preference, but just as the good Lord gave you a favor and spared your life, as well as keeping you from incarceration when you killed that African-American woman on Central Parkway, thank you very much. Please do something with Judge Hunter. You are a fraud. Thank you for your time. Hamilton County taxpayer. Judge Nicklocker, we demand you drop the charges of Judge Tracy Hunter. Do it now. Exonerate Judge Tracy Hunter now. Economic boycott of Cincinnati until Judge Hunter is exonerated now. Judge Nicklocker, bring back justice for Judge Tracy Hunter. Black judges matter. She made us as important.
So, the thing about the judge hitting someone, a while back, in 2014, he was a judge. He was a Judge Dinklager was an appeals judge, and he came down and ran for common pleas judge. So common pleas is a trial court judge. A coked out lady was in the middle of the road during rush hour, like at a late hour, and she got hit by two people, and one of the cars was driven by the judge, and another person hit this lady and killed her. But she was like coked out of her mind and standing in the middle of the road, like nowhere near a crosswalk. So that's what they're talking about with the whole he killed someone thing.
He made an important difference for our children. Exonerate her now. Dear Honorable Dinklager, remember you killed someone and your privilege got you off. No, I do. Just came to my house, okay? See, well, you could make things right by taking your foot off the neck of former Judge Hunter, a holy woman. There are bogus claims, a bogus charge for which he is convicted. How is it you get 0 jail time, no consequence for killing someone, and Pastor Hunter loses her good name and does jail time? God bless America, Hamilton County taxpayer. And the last one I'll read. Honorable Judge Dinklager, boy, that is used. Perhaps perhaps do one good thing before you meet the maker in the sky. Since you are a killer, maybe doing something right for points will help your eternal judgment. Exonerate Pastor Hunter and former Judge Tracy Hunter. I know you will not, but you will not be able to tell your white Jesus that you were not asked. Sincerely, Cincinnati taxpayer.
Your Honor, could I just be heard very, very briefly
No.
on that?
Having said that, I now refer to Rule 2.4 of the Ohio Code of Judicial Conduct, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. B, a judge shall not permit family, social, political, financial, or other interests or relationships to influence the judge's conduct or judgment. And C, a judge shall not convey or permit others to convey the impression that any person or organization is in the position to influence the judge. Having said that, I say to the organizer that did that, and obviously it's organized because these will be made public record.
Yes,
Every one of them has a
struck
label.
coked out
addressed to
pedestrian
Judge Dinklager at my
who
house.
ran into traffic.
The stamps are all the same. So somebody organized that for whatever reason. But I just hope no judge ever has to go through that, but be that as it may. We'll move on. I will point out that I will say to the organizer and some of the people that wrote those postcards, I don't think some of them were very Christian, but that's the way it goes. I will say to them, though, if the attempt was to intimidate me in any way, that has flat out failed. Okay? I will never, ever, ever bow to that type of pressure, veiled threats, vicious comments, lies about me, or anything else. I've been a judge for 28 years. For the first time that I do something because somebody has threatened me or pressured me to do something, it's the last time I do it because I'll never be a judge. I don't want to be a judge anymore. I will not violate my oath. Having said that, I do need to point out that Pastor Peterson Mingo, Councilman Christopher Smitherman, the Black Lawyers Association, the Southern Christian Leadership Conference is signed by Edith Thrower, who I know is a very good person, and Mayor Cranley have all written what I believe are appropriate letters to me that I have read, and I will attach what significance I can, but I wanted to put on the record that they did it appropriately and did send me letters, which I have read. With that, then, we are now at the aspect of the execution of sentence. Again, they're not a hearing sentence, and I'm not even sure if it's necessary, but in the spirit of allowing everything to be done properly and
We'll get to this.
Making sure the due process of Ms. Hunter is taken care of. Ms. Branch or Mr. Singleton, did you want to say anything at this point?
I do, Your Honor, and this perhaps might not be necessary, but the reason I popped up to respond as I was listening to those postcards was that I'm sorry that you had that happen at your
All
home.
right, it's fine, it's fine.
Tracy Hunter did not send those postcards. And I think when you said the organizer of it, you probably made the point I was going to make, which is that this case has been followed. It's generated a lot of passion and interest in the community. And Judge Hunter can't control what other people do. And I just wanted to say that. And I'm really sorry about the impact that that's had on you. I don't want to repeat too much of what I said before, but let me say this on execution of sentence. We've asked for the time to file our motion to dismiss or to stay, which we would hope you would do. If you're not going to do that, then what we're asking you to do is not send her to jail and not put her on probation. Yes, this sentence was imposed by Judge Nadel, and you said earlier that your job today is to follow the law and execute the sentence. But that sentence is not just. Our belief, and we'll continue to litigate this, and I realize that you're not in a position to agree with us on any of this, is that the conviction is unjust. But 6 months in the jail for a felony for someone who has never been in trouble before, and someone who has been a positive and is still a positive impact, has a positive impact on our community, that's not just. And I would ask you, Judge Dinkelhofer, to rise above, and not to suggest that you're not rising above, but I know some folks have personally said things in those postcards that offended you. I would ask you to turn the other cheek on that, not tar Tracy Hunter with it. And also do what's just today. I don't think there are too many people who in this community, and including Joe Dieters. I mean, the letter was not saying send her to jail for 6 months. The letter was saying something else that we happen to disagree with. But I don't think there are too many people in this community on both sides of the aisle, in prosecutor offices, in defense lawyers' offices, people on the street who believe that this sentence is right, putting aside whether the conviction is right, which we contend it's not. So I would ask you on behalf of Tracy Hunter.
You guys know what happens. Don't spoil it for the people who haven't seen it.
End this today for her. She has had, as a result of this case, she's lost everything almost. There's something that's important that she has held on to, but she's lost a lot. She lost her job as a judge, her law license, her ability to earn an income.
She got convicted for being corrupt, and she's going to jail for 6 months.
As I said, not knowing when that day was going to come that she'd have to go to jail. That's a lot for one person to have on her shoulders. She's held on, though, to her character. And she has continued to serve the community through her pastoring, her church.
Yeah, because you want her to be your pastor.
Ministering to her flock. She has an elderly mother who needs her. I would ask you to take that into consideration as you think about what is just here today. And so my request to you, Judge Dinkelhofer, is not to execute the sentence that was imposed. Give us time to file our motion to dismiss. But in any event, please don't add to Tracy Hunter's burden, the burden that she's carried for these past 5 years. Thank you for listening.
Thank you very much, Mr. Singleton. Ms. Branch, do you want to say anything there?
Nothing additional.
Thank you very much. Mr. Crosswell, anything, sir?
Your Honor, I came here today with the intention of saying nothing. But frankly, based upon the arguments that have been made, I think I would be negligent in my duty and obligation to the state and frankly to the court to not make the point that there are certain things that, as you know, I've never prosecuted a case before. I have practiced criminal law for 45 years, and there's certain lessons I believe that I've learned in the practice of law. And one is that if you represent someone who is convicted, it is important that the person who's convicted show genuine remorse. And that's something that is traditionally taken into account by courts when they sentence. And frankly, Mr. Singleton is honest when he tells you that Tracy Hunter is unrepentant. She has no remorse for anything that has occurred here. And frankly, she continues to lash out. And I do find it somewhat ironic that it's said that Tracy Hunter knows nothing about the cards that were sent to you, yet she is the very person who made those allegations to you, to your face, in a court hearing some time ago. And I would say that very few things have ever affected me in court. And when she started on that rant, I cannot describe what I felt, not only about the inappropriateness of it, the brazen disregard for respect and authority, but the frankly, what I thought was malicious and vicious allegations to make against you or against any judge, and especially under the circumstances of the event that she wants to continue to rehash. Your Honor, it's ironic also that when Mr. Dieters wrote the letter asking you to at least order a mental health evaluation, and I endorsed it. I said, well, that's fine with me. It's somewhat ironic that the person who said that they did not want the mental health evaluation was Tracy Hunter herself. Now, anyone who has been in the system or around the system understands that when Mr. Dieters presumably is asking for a mental health evaluation, it arguably would be to see if there is some type of way for Tracy Hunter to avoid a jail sentence if there is a mental health issue. Yet she is the one who stands here before you today and says that she doesn't want that either. In other words, what she wants is to control the facts. What she wants to do is write the law. And what she wants to do is play by her own set of rules right up until today. I mean, right up until this very moment. And that's the very attitude and the very conduct that put her in the predicament that she's in, and frankly has caused all this pain to her and caused all this turmoil to the community. That said, the case, correctly as has been said, has been tried. A jury has convicted her. It's been through the First District Court of Appeals. It's been through the Federal District Court, and the convictions have been affirmed at all times. She stands convicted. There is a sentence which was imposed by Judge Nadel, and I think it's time to impose a sentence.
Mr. Singleton, Ms. Branch, if Ms. Hunter would like to say something, obviously she's more than welcome to say something at this point. It's up to you all.
Joe Dieters, okay. Yes, when you guys heard Joe Dieters, he was the prosecutor of Hamilton County. He did not prosecute this case. This was done independently. Now Joe Dieters is on the Supreme Court is in the Ohio Supreme Court. So.
Just one moment.
Yes, sir.
Matthew Moore, dude, how are you doing, man? Yeah, once again, this looking like some bad. This is really bad cops, like malicious cops.
Thank you.
Even worse,
Then
like
perform my duties as a judge to ensure
Yeah.
complete and full due process.
not just a
has been
competent
afforded
cops,
to Ms.
bad
Hunter,
cops.
As it is to every defendant in this courtroom. I have reviewed the entire file.
So I hope you're
including
doing well,
federal
man.
aspect and pertinent law.
I'll shoot
It's
you
a
an
real
email
quick
soon.
review, so there's a full understanding of where we are. And how
Look
we
at her
got
eyes. She
here.
got crazy
This
eyes.
obviously was an investigation of things that allegedly were done improperly by Ms. Hunter in juvenile court. A special prosecutor was appointed by the Common Pleas Court. They did an investigation. Matters were submitted to the grand jury. The grand jury returned a multi-count indictment. There was a jury trial conducted by Judge Nadel. 12 jurors, 12 peers of Ms. Hunter, found her guilty of one count of having an unlawful interest in a public contract, which was signed by all 12 jurors. The sentence was imposed by Judge Nadel on December 5th, 2014. He imposed that sentence, Judge Nadel ordered Ms. Hunter to to come to the Justice Center on the 29th of December 2014 to begin the sentence that was stayed by our First District Court of Appeals. On January 15, 2016, in a 3-0 decision, the First District Court of Appeals from the trial court found that Ms. Hunter had received a fair trial. The Ohio Supreme Court, in an entry dated May 18, 2016, and I quote, declines to accept jurisdiction pursuant to Supreme Court Practice Rule 7.08b4. In other words, there was not enough there for the Ohio Supreme Court to even review the case. They didn't take it in. They lifted their stay. They said, go ahead, court, proceed with the execution of the sentence. The defendant then appealed, filed a habeas corpus in the federal court. Judge Black then stayed the execution of the sentence. After that, federal magistrate Judge Karen Likovitz reviewed the case. On May 9, 2017, she submitted a report and recommendation to Judge Black recommending that Hunter's petition for writ of habeas corpus be denied with prejudice. The defendant objected to that report, and on May 29, 2019, 2 years later, Judge Timothy S. Black, the United States District Judge, issued a decision. I think it is appropriate at this point to just, I've read it, to share for the record a couple of things. On page 2, and I quote, early in these proceedings, Hunter's attorney stated, quote, regardless of whether this federal court ultimately agrees with Judge Hunter on the merits of her claims, this case presents an opportunity for the federal court to restore lost confidence in the justice system by giving Judge Hunter a fair opportunity to be heard in federal court, a venue that the community trusts as being above local politics before she is put in jail. Judge Black then says this federal court now discharges that duty with this decision. He goes on further on page 22 to say, the last paragraph, nevertheless, in summary as to this objection, the evidence at trial that Hunter had delivered to her brother documents to which he was not entitled for the purpose of protecting his employment as a juvenile correctional officer.
Very likely
at
she
the
was
Hamilton
making
County
bribes
Youth
as
Center,
well.
as well as the testimony regarding Hunter's additional
I was never
conduct
charged.
intervening on her brother's behalf, and I quote, strongly supports the jury's verdict that Hunter was guilty of having an unlawful interest in a public contract. That's the federal judge saying this. The federal judge goes on further to say this strong evidence, I quote, strong evidence supporting the jury's verdict on count 6 undermines petitioner's claim that the verdict was a result of the inflammatory and prejudicial effect of remarks made by the special prosecutor during closing argument. On page 25, the federal judge, Judge Black, then says, conclusion, number 1, the report and recommendation is adopted in its entirety. That is Magistrate Likovitz.
Guys, we're getting to
Two,
the good part
petitioner's
here.
Objections and respondents'
We're getting to the
objections are
sex.
overruled. Skip 3, 4. Petitioner's petition for writ of habeas corpus pursuant to 28 U.S.C. section 2254 is denied with prejudice and dismissed. Goes on in paragraph 7. The court's prior order granting petitioner's emergency motion for stay of execution of sentence is hereby set aside and vacated. And 8, the court shall enter judgment accordingly, whereupon this case is terminated on the docket of this court, that is the federal court. After that,
He's pointing out
he's
all
represented
the
by very, very good
exhausting
lawyers.
of her
Lawyers then
appeals.
went to the Sixth Circuit Court of Appeals, where they filed for a writ of habeas corpus. I'll just read part of the last page in their order, which was dated July 18, 2019. And I quote, Hunter has not demonstrated she is likely to succeed on the merits of her claim that she was denied a constitutionally fair trial as a result of the improper remarks by the prosecutor. Goes on to say she has not demonstrated she will suffer any additional irreparable harm in the absence of a stay. And the United States Supreme Court has noted, quote, the state's strong interest in enforcing its criminal judgments without due interference from federal courts. The interest of the state and the public in the finality and enforcement of judgments supports the denial of stay pending appeal. Accordingly, the motion for stay pending appeal is denied. That's by the Sixth Circuit Court of Appeals. So with that, I've read it once. I'm not going to go through it again. Just to note, all the state courts have looked at this. Every one of them said that Ms. Hunter received a fair trial. We went to the federal court. You can shake your head if you like. The federal courts also said she received a fair trial all the way up to the Sixth Circuit Court of Appeals. The only thing left is the Supreme Court, and I doubt that they're going to take it in. They all did their duty, and now it's my turn. To follow my oath, uphold the rule of law. In this case, the law certainly permits it. And I believe justice. I'm sorry.
I'm sorry to interrupt. Just 1 second.
I don't know why you'd interrupt. There's literally nothing you can fucking do at this point.
I'm sorry.
There's nothing. There's nothing. I would not be interrupting him. This is not a good look. Normally, I'm not afraid to jump up and interrupt. That's my thing. But literally, there's no reason. Well, he can't get any worse. She's already been sentenced. He's just meant to carry it out. I've interrupted the judge before. I've interrupted judges, Your Honor, and there's times where you have to do it. But this, There's nothing they could do. There's nothing you could do here. Harry Stevens got a great idea. Someone should sell snow cones outside the Karen Reed trial. Brilliant idea. $1 million idea, chat. Somebody in Massachusetts, I know that you're out there. Go start selling snow cones, guys. Sell gelatos. And put little cars. Sell gelatos with little Matchbox cars on them. Boom! Red snow cones with little cars on top. $1 million idea, chat. Let's go! Let's go make money, chat. Fuck Grant Cardone. Fuck Dan Pena. I'm your millionaire mentor. I can help you make money, chat. Go make it. Get that bag. Case closed with CJ says, hello, sir. Sorry for asking us here. I'm a creator covering Delphi. Hold on here. There should be CJ, come here. Hold on 1 second. I'm gonna.
I gave her an opportunity to speak, and that was turned down. It's not being offered now. Please have a seat.
So you're denying my right as a defendant to address the court.
Ma'am, please have a seat.
You've already kind of pissed that away.
Thank you, ma'am. The record should reflect again, you were offered an opportunity to speak.
Sorry about that, CJ. But yeah, here's my email, potentiallycriminal@gmail.com. I thought I normally have like a whole information thing down below.
Please, everybody's been great. I appreciate that. It is a court of law. Thank you for that. As you all heard, she was offered an opportunity to turn that down. With that, in this case, I believe the law permits the execution of the sentence. And I believe, I know justice gets thrown around a lot, but I think justice demands in this particular case. So the court, Ms. Hunter, orders the execution of the sentence imposed on December 5th, 2014 by Judge Nadel. That is as follows: 1 year community control, that's non-reporting. Since you will be on community control, I will advise you, as I'm required
1 year
to by law,
probation.
that if you violate any of the conditions
No big deal.
of the community control, come back in front of me. I will sentence you to 18 months in the Ohio Department of Corrections. It is a felony of the 4th degree. The conditions of the community control are real simple, as indicated in the judgment entry by Judge Nadel.
In addition,
Number one, you pay the
CJ,
cost
if
of the
you
proceedings.
refresh, it should have my email and everything down below in the description. My apologies for that. But yeah, send me an email. Send me an email. I'll be happy to talk to you.
Number 2, you are to do not violate any laws. Number 3, you are to do 6 months in the Hamilton County Justice Center, credit 1 day. Mr. and Ms. Deputy can take her away.
And wow, that got the last bit of that got really fast here. Hold on, we'll rewind that, and we'll go a little slower here.
Number 1, you pay the cost of these proceedings. Number 2, you are to do not violate any laws.
Yeah, here you go.
Deputy can take her away.
That corporal's just standing there like, I hope somebody fucking runs up here. He's like, I'm gonna whip someone's ass. So there you go. That's what happened to her. And there is a court cam. So A&E covered this. Here
We
is
now
the
head over to
actual.
Hamilton County Common Pleas Court in Cincinnati, Ohio.
Yeah, see, this is the actual like bird's eye view. And look, these are I've been in that courthouse. It is dope as fuck. It's so cool. It's old school. It's so cool.
For the controversial sentencing hearing of juvenile court.
So here we go. Yeah.
Outraged.
So yeah, here we go.
Mr. and Ms. Deputy can take her away.
Here we go to the sentencing.
Hunter's supporters are outraged. In fact, keep your eyes on this woman as she attempts to approach Hunter, but is intercepted by court officers. Then watch closely. As this deputy attempts to take Hunter away, initially she seems to resist. But then, perhaps realizing that her time has run out, her body goes totally limp. While shouts of no justice are heard from the gallery, she's literally dragged out of the courtroom. As tempers flare in the courtroom, Hunter's put in a wheelchair and processed, while her supporters exit the building and rally outside. Hunter eventually begins serving the 6 months at the Hamilton County Justice Center.
And she got released after 75 days, so. Yeah. How long ago was the sentencing? 2019. So, yeah, it was a long time ago, but Nate covered it, but I remember when it happened, it was hilarious. It was absolutely hilarious when it went down. Yeah, did you guys, let me see here. Ohio's answer to Fannie Willis, yeah, well. Read the room, there's nothing more to say. Yes. Yes. Bernice Conklin says, I live in Massachusetts. I'm serious. Go sell some snow cones. People will buy those. You could sell a snow cone to Turtle Boy. I'm sure he'll buy one. It's barely 50 degrees today. Okay, well. And Charlie says, I've interrupted the judge before, too. I was already in handcuffs and shackles. What else could they have done? Well, that's fair. That's fair. Chip says, guess who made a special appearance on Future Conflict today? Nick? Oh, boy. I'm just kidding. I'll have to watch it later. Sean gonna buy the Dallas Mavericks with this idea? By the Denver Broncos. Just like Homer got. Why the fuck is she trying to speak now? Because she's an idiot and she's trying to control stuff. And we're gonna switch over to Long Cuck and get ready for the Trizile to start back. And we're going to put that in the cone and keep going. This judge being super patient. Yeah, Jed, you know what, though? The cake has already been baked. His job is just to make sure, this person, the defendant, eats their piece of cake. So, that, this way, there's never any question he acted improperly. They can't appeal this. There's going to be no grounds out of it. That's why he did it. Yes, this woman passed the bar. Yep. I'm a mess with his producer on vacation. Well, that's how it goes. Snow cones served out of shoes. Boom! Even better, chat. We've got this, guys. We've got this. Shoe-shaped cones. That's perfect. Perfect. Fine, we'll do Hawaiian ice, but whatever. Godshot says she was fighting 6 months this hard. For a lot of people, 6 months in jail is not fucking good. Also, she feels she's been oppressed by my system and all that. But yeah, I don't want to go to jail for 6 months. I'd fucking suck. I'd fight. Who's doing all the shouting? The audience saying, she didn't do nothing wrong. Coolio's top notch. Yes, he is. Shit. Yes. She needs a Hickory shampoo. Well, that lady did not get punched in the face. She's very lucky. That lady ran up there. So who was that lady? She was a former juvenile court judge in Cincinnati, Ohio, and she basically got convicted of misusing public contracts, forgery, like very likely she was taking bribes and things like that, but none of that was ever proven. But she was convicted of the misuse of contracts. That's at least a class 2 chip. Oh, yeah. I mean, that was a pretty good one on the scale. Who's the lady in the back that ran up? Just one of her crazy supporters. And Squizgar says for $5, it is no accident there was a black female CO to drag her out. Well, that wasn't a CO. That was a deputy sheriff. A sheriff's deputy. In Ohio, courtroom security is provided through the sheriff's office. Because unlike out east, like in Massachusetts, counties don't really have much governance. We don't have state police. We don't, like in New York, there's no armed court guards, like organization at the state level that provides guards for everybody. The local sheriff is in charge of doing court security in Ohio. See, and we now know how the LA riots happened. Yes. Under review says, I just turned the stream on, and what do we have? Yes. A woman getting her just desserts. Were they going after her or after them for arresting her? I think she thought she could prevent them from arresting her. I don't know. I'm sure if you asked her, she had no idea what she was going to do. Sounds like the sounds of hell in that recording, yes. Unhung Hero for $2 says, who let the apes out of the zoo? I don't know. They did. Bria says, I don't know how these people are that dumb and supporting her misconduct. That happens in a lot of cases. I mean, a lot of people, the idea that somebody's going to say, oh, they didn't do nothing. Didn't do nothing is across society. It breaks all racial bounds. It breaks socioeconomic bounds. People generally think they're part of my church. Oh, they didn't do nothing wrong. Then my family, they didn't do nothing wrong. Happens all the time. Oh, we're getting ready. Want to catch up here. How do you get a job as a deputy at a courthouse? You have to join the county sheriff's office.
Well, is the session please be seated?
All right. Why don't we get the lieutenant back up here? Thank you.
And sir, I remind you, you're still under oath.
Okay.
All right, guys, here we go. We're back. We got through lunch in one piece, chat. I haven't had lunch, so I'm hangry now. Oh.
Go right ahead, Mr. Lally.
So Lieutenant Woodbury, turning your attention back to the treatment of Mr. O'Keefe in the back of the ambulance. Right?
Yes.
With respect to that, you testified that you don't recall sort of specifically anything as far as clothing for Mr. O'Keefe. Is that correct?
I was not paying attention to the clothing.
And so to that point, what were you paying attention to at that?
Primarily, the big issue was doing the CCR, then just CPR. We're trying to resuscitate the person as best we can. We know with the hypothermic patient, it's very difficult. It's a longer treatment protocol than a typical cardiac arrest because we have to do the CPR for an extended period of time. We have to get the patient warmed up. So the clothing is just quickly removed versus examined or looked at. And the focus was on getting compressions done. Someone was trying to intubate, getting a line started. So that's what we're mainly focused on.
As far as treatment is concerned, what, if any, sort of interplay or intersection is there between a cardiac arrest and a hypothermic patient?
When someone's hypothermic and in a cardiac arrest, we can't declare them dead or passed on until they've been warmed up. A lot of times with hypothermic patients, they can appear to be dead when they're still actually alive. So there has been instances where people have woken up in morgues that were hypothermic when their body warmed up a little bit. So we have to be very cautious, very careful about treating them as much as we can, as careful as we can. We can't shake them too much, can't move them too much. So it's getting the blood circulating and then starting ventilating after a few minutes.
Circling back to the CCR, the chest compression
Yep.
that we're talking about, what if any sort of, based on your training and experience, what if any sort of protocols are, well, let me ask you this, were you doing chest compressions throughout the entirety of this interaction with the patient?
No, chest compressions, most people do them about 2 minutes. After 2 minutes, it's very tiring to do chest compressions, so we swap off every few minutes. So a different person will come in and do the compressions. They'll do it for a little while, go into a different task. Someone else will come in and do compressions.
Is that sort of the protocol?
No, you did not miss any. Don't
Yes.
go back. There's nothing
Yes,
worth
we were
watching.
rotating her
I
person doing
promise.
compressions.
It was 15 minutes a waste
And
of time.
the ambulance at some point leaves the scene and goes to a hospital, is that correct?
Correct.
Do you know what hospital, Mr.
Good Samaritan Medical Center.
If you could just wait till.
Yeah.
Sorry, I'm sorry.
Questions.
Yeah, a Good Samaritan Medical Center.
And did you go along for that ambulance ride?
No, I did not.
And where did you go?
So as the lieutenant on the engine, I stayed with the engine. I detailed my 2 other engine personnel to the ambulance. So they went with the 2 engine personnel, the 2 regular people on the ambulance, as well as an additional person. Timmy Nuttall was the extra person for that one.
And so you take the engine and go with it.
I went back to the station.
And at some point shortly after that, are you called back to the roadway of Fairview Road?
Yes.
And same general area of Fairview Road?
Yes, same address.
And how is it that you get from the station back to Fairview?
So we had struck a box to cover the personnel that we had detailed. That means we send out a page looking for additional people to come in. We had Sam Pock come in. So he was my engine driver, and I was in the lieutenant's seat. We responded back in engine 4.
And the ambulance that had been there on Fairview Road with you previously was at Good Samaritan?
Yes. Yeah. A call like that takes an extended period of time, even at the hospital, to assist them there. So we had to get an ambulance from Station 2.
And if you know, who was on that ambulance from Station 2?
That was Jason Becker and Dan Whitley.
Now, with reference to this particular call, what, if anything, was this secondary dispatch with regards?
So this call was for a Section 12, which is someone in having a psychological issue.
And do you know who that Section 12 was in regards to?
Yeah, this was for Karen Reed.
And at some point, you go back to the scene along with the engine and the second ambulance from Station 2?
Yeah, so the engine got there first. The ambulance coming from another station, so it was a couple extra minutes before they got there.
And when you arrived,
I don't see how that's
anyone else
relevant
was
saying
sort of
Karen's crazy.
on scene on Fairview Road at that?
The police were still on scene. They had never left. So initially it was me, Sam Pock, and the police. So I went up to try to get the backstory of why we're doing a Section 12. And
Sam Pock, like Tupac?
And at some point, well, when you first
Tupac,
arrived,
one Pac
without
done.
regard to what was said to you, but who, if anyone, do you speak with to sort of try to gain this information or backstory?
When I got onto the scene, I talked to the police that was there.
Who'd you talk to, sir? The police officer who
Police
was there?
officer, yes. Sorry.
The police officers
And
though.
do you recall specifically who that police officer was?
I really did not pay attention to the individual officer.
And at some point, do you have a conversation, or what, if any, conversations do you have with the patient, in this case, the defendant, Ms. Reed?
So it was when we identified Karen Reed as the patient, the ambulance arrived shortly after. We started talking to her and trying to get her into the ambulance to talk to her further.
And just to be clear for the records, when you say Ms. Reed, do you see her in the courtroom today?
Yes, she's right over there.
That's a record reflect identification of the defendant by the witness?
Yes.
Now, with respect to the defendant, Ms. Reed, where is she sort of when you first make contact with her on scene when you come back?
In the general vicinity of where the police cars are.
And what is sort of the purpose of this initial conversation that you're having with Ms. Reed?
For Section 12, that's when someone's made threats to them, harm themselves or others. So I just had to judge her mental ability at the time and if she was a threat to us and how much of a threat she was to herself. So just a quick evaluation, see how her behavior was.
And what, if any, observations did you make of her during your quick conversation?
She appeared very distraught, very upset. Initially just trying to explain the situation to her about going to the hospital with the Section 12, and she was resistant to that.
And so when you say she was resistant to that, what if anything, did she say or do to?
She did not want to go.
Hold on. You cannot talk over each other, and the objection's overruled.
Yeah. Okay.
Please go ahead.
So what was the question again, please? Yeah.
So what, if anything, when you say she was resistant, what, if anything, did she communicate to you or observations did you make in regard to that?
She did not want to go to the hospital, and she didn't think she needed any assistance.
And what, if anything, are you sort of, you mentioned you were explaining sort of the process to her. What, if anything, are you saying in that explanation?
Well, once a Section 12 gets written, it's written by the police. Once it's written, we are required to transport to the hospital. Section 12 means that they believe you're a threat to yourself or others. So you have to get evaluated at the hospital by the hospital staff there to see how mentally stable you are.
Now, at this time of this conversation, what, if anything, did you know as far as the relationship between Ms. Reed and the prior patient, Mr. O'Keefe?
I knew they had a relationship. I wasn't sure if they were married or engaged or what their status was, but I knew she was did have a strong relationship with him.
And in reference to Mr. O'Keefe, during your conversation with Ms. Reed, what, if anything, was she asking or saying in reference to Mr. O'Keefe?
She kept repeating, "Is he dead? Is he dead?" She seemed very concerned about that. We're trying to explain to her that we cannot declare him dead. He's being evaluated. He's being treated. They're trying to treat him the best they can.
And as far as when she's stating these things to you, is this, as far as the sort of tonality of her voice while she's stating these things to you, can you describe that?
She was very up and down. It was a repetitive conversation with her. She's obviously experiencing a lot of different emotions. So just her emotional state was all over the place.
And as far as this sort of second time that you're on scene, about how long period of time are we talking?
That was about between 15 and 20 minutes.
And as far as your conversation with Ms. Reed, where did she go? Did you stay with her sort of the entire time that she was on scene that second time, or?
Because she was resistant, we were trying to get her to voluntarily go. If someone voluntarily goes, even with the section written, they're released a lot quicker. So we're trying to convince her to go, be willing to go with us versus being forced. If at some point we have to actually force her to go against her will, then it's going to be a much longer hospital stay. So our main goal with staying on the scene so long was to try to get her willingly to go. Just makes her experience
part of
much
that
better.
Meant to cover up the crime by having her removed and declared crazy?
It was me, Dan Whitley, Jason Becker were the ones talking to her in the back of the ambulance.
When you clear, sort of when you leave the scene, where is Ms. Reed at that point?
So the ambulance transported her to the Good Samaritan. We also detailed Sam Park as the driver.
So the gentleman who had driven, or the firefighter that had driven you in the engines of the scene that drives the ambulance away?
Yes,
Would
correct.
you say his name again, please?
Sam Park.
Sam what?
Sam Park.
Spell it, please, the last name?
P-O-C-H is the last name.
Oh, okay, thank you.
Thank you, sir. I have no further questions.
Okay, ready?
Thank you. Good afternoon, sir.
Good afternoon.
Mr. Woodbury, you and I have never met or spoken, correct?
No.
I know you had said you were nervous, so I'm going to try and make this fairly brief,
Thank you.
sir. I just have a couple of areas that I'd like to go through with. So with regard to your interaction with Karen Reed and
what you actually heard from her mouth.
Okay.
That's sort of where I want to concentrate, as opposed to anything that anybody else may have said to you about what they believe she might have said. Okay?
Okay.
And it seems to me that your main interaction with her was not when the initial call came in to respond to, a man who was unresponsive in the snow. It was after you went back to the station in the engine and then came back to the scene for the purposes of the Section 12 that you described. Would that be fair to say?
Correct.
And when you came back to the scene for the Section 12, it's also fair to say that the Section 12 issue was your focus, correct?
Correct.
You had an order in hand, correct?
The police had it and they gave it to us when we got there.
Right. Okay. So you got an order in hand once you got there.
Correct.
Which is what you expected to happen. Correct?
Yes.
And your focus at that point is, okay, and I don't want to be too, flip, but we can do this the easy way or the hard way. Is that a fair characterization?
That is one way to put it.
And you wanted to do it the easy way.
Yes, correct.
And you wanted to persuade Karen Reed that she should want to do it the easy way, correct?
Yes.
And after some conversation back and forth where she was initially resistant, she eventually agreed, yes, I'll do, not to put words in your mouth or hers, but to the effect of, yes, we'll do this the easy way, correct?
Did get her to agree to transport.
And with regard to her state of mind, I believe you had testified that she appeared to be very distraught.
Yes, correct.
Going through a lot of emotions.
Yes.
Grief-stricken.
Oh, that's one of them, yes.
Hysterical at times.
Yes.
Raising her voice at times.
Yes.
Crying at times.
I didn't see any actual tears, but that type of emotional display.
All right. And so in terms of the only commentary that you heard with regard to her feelings or questions regarding John O'Keefe, it was the statements that you heard repetitively over and over and over again. Is he dead? Is he dead? Is he dead? Is he dead?
That was some of the things she was saying, yes.
Your Honor, may we approach sidebar briefly?
Okay.
Oh, we're getting a sidebar. I think we're going to get into something. I wonder if we're going to get into like, hey, like everybody underneath you is fucking lied so far. So what's this all about? What's this all about here, man? I do think that's interesting. She's acting all, we need to take her and get her sedated. Well, that's mighty coincidental. Mighty coincidental in my opinion. Almost like they're trying to make shit happen. So, yeah, that was really, really cool. That's really sus. And that he went along with it. I don't know, man. Yeah. Yep. The defense got another, they're going to do something. And this must have been a motion in limine issue because now they're approaching to talk about it. And the judge immediately said, yeah, come on up. I think she knows where they're going to. So. Franco's just getting this right. They leave the scene. Well, they're getting ready to leave the scene, and O'Keefe has already been removed. And now they want to lock her up for a mental health issue. Yeah, I don't Yeah. Yes. Coincidental she was saying sectionable shit? I don't know. Remember, you can't trust half the paramedics because they weren't fucking telling the truth. So, I don't know who you trust right now. It's funny watching Turtle Boy become more correct. This world is ending. Well, it's not his fault, not attributable to him.
So I
Lieutenant Woodbury.
I think, Ms. Giannetti, I think you need the actual,
Yes.
This judge has like resting bitch
I was
voice.
going to ask a
Like,
couple of questions first and then grab it.
but it's right there for when you need it.
Lieutenant Woodbury, on your direct examination, you testified a bit, and I don't want to block a jury here, I'm sorry. You testified a bit about the injuries that you observed on John O'Keefe when you first arrived at the scene, correct?
Yes.
You testified about the swollen eye,
Yes.
and you also testified about the scratch marks that you saw on his forearm, correct?
Correct.
I'd like to show you, I'm going to approach in a minute, to show you what has been marked M for identification. And when I hand it to you, please keep it to yourself and look at it, and then look up at me when you're done, okay? Having reviewed M for identification, do you recognize what that depicts?
Yes.
What does it depict?
That is Mr. O'Keefe's right arm.
Does that photograph appear to be a fair and accurate representation of the scratch marks that you observed on January 29th of 2022, sir?
Yes.
I would offer that, Your Honor.
Okay. That will be our next exhibit. And again, we'll have to maybe renumber. Counsel, before you leave today, we have to figure out how to keep everything straight.
Understood. And with the court's permission, Your Honor, may I have that published on the screen for the jury?
Yes.
Now, on direct examination, Lieutenant, hang on, let me just have a moment. Oh, good point. I'm going to try to get out of your way so that everybody can see. With regard to the injuries that you described on direct examination, Lieutenant, I believe you would mainly concentrate.
I'm sorry, I need to, please take this down for me. I need to counsel.
whoa, what just happened? What just happened? All right. Why is she changing her mind? I mean, it got up. It got presented.
With regard to the injuries that you described on direct examination, Lieutenant, I believe you would mainly concentrate.
I'm sorry, I need to, please take this down for me. I need to counsel.
Why is she taking it down? Is this not what she thought was going to happen? I mean, like, I just double checked. I'm like, it's what we thought it was. We'd already seen these autopsy pictures. What is she freaking out about now? And I don't get it. I don't get it. Judge Karen needs to like get her shit under control. Which is funny because Karen's just sitting there minding her own business. So what is happening? This judge is terrible. It's like she doesn't know what the fuck she's doing. Yeah, no takesy backsies. They look like defensive wounds. They don't look like a dog bite. Certainly they could have checked for dog saliva, but that doesn't even look like what a dog attacking somebody. Like, it's not dog bites, and dogs wouldn't... I said she was good, but what the fuck is she like? Her huffing and puffing is getting annoying. It's all this woman does now. Exasperated sigh. Dog claw marks look like that, but it wouldn't. If the dog's clawing you that aggressively, there'd be bites, though. I mean, that's how I'm looking at it. There'd be like some dog. The dog would have been biting and fighting, not just going like, ah, ah, Ah. Yeah. Karen toned down on her makeup. Yeah, she did a little bit. Yeah, a dog claw would have to be sharpened to do that. That's what I'm confused about. They don't got tire marks. Yeah, attack raccoons. So be big raccoons do that. Biggest raccoons imaginable. Well, we're on the ceiling now. Oh, come on. What do we got? Oh, the jury's out. The dog's nails freshly trimmed. I don't think so. I mean, those are raised, like those are sharp. You need sharp claws to do that. And also, when a dog, I mean, when a dog's scratching, its paws all one thing. It doesn't like. So I just don't. Those don't. Yeah. They don't like a cat would scratch and it'd be nice and wide. But the dogs, I feel like, would be tighter on that. Kansaki says I'm wrong. I'm fine. I'll be happy to be wrong, but I understand the nails are sharp, but that looked real fucking sharp. There's no fence around. It's an open area. So. Jack says, my 18-pound dog scratches the crap out of me. Up on her hind legs coming down. Those aren't dog claw marks. We all agree it isn't road rash. I would agree it's not road rash. What's with the tape line? That's to keep people away from the jury. They're limiting the amount of... Because the closer you get this way, you could interfere with the jury. I think that's their way of limiting the courtroom. It's just a do not pass line. James says, not a lot of bleeding unless they cleaned it. Well, remember, he's dead, so there's not blood coming out. And yeah, it would have been cleaned and looked at. But also, remember, too, he was ice cold. Being cold slows down bleeding. That's actually, in winter and Arctic combat conditions, people have survived, things that would normally kill them in a more temperate climate because the cold does slow down the body and it constricts things. So that does happen. Yeah, the EMT said he was wearing. He said he's wearing like a light. I thought they said light jacket, not a puffy jacket. I thought it said light jacket. So ice can cause bad wounds. Yeah, it can, but I don't know about wounds like that. Turtle Boy must be pissed that Rita is in court, not him. I don't know who Rita is, so. It's like a broken bottle. I don't think it looks like a broken bottle. That would have a lot more interesting cuts. They said clothing inappropriate for the weather. Yeah, he would have to be major track marks. Yeah. I think at some point we're going to have to see the clothes. If the state doesn't have them, they're fucking it up. Did the jacket have any rips in the fabric? Jessica, I don't know. I do not know yet. We haven't seen the jacket or any of his clothes. Tammy says when a dog bites and you pull away, the skin will rip. Yes, but that does not look like, those don't look like dog bites, though. So explain Turtle Boy. Turtle Boy is an investigative journalist who's been on this from the beginning. Turtle Boy is a lol cow. And Turtle Boy has also been repeatedly dishonest in a lot of ways. So, him banging the drum saying Karen Reed's innocent really wasn't a way to convince me that Karen Reed was innocent. He then also got in trouble for tampering with witnesses and harassing them with his mob. Fun fact, dogs tomorrow leave scratch marks if you put oven mitts on their paws. So, it's hard to take somebody Turtle Boy seriously. Well, we all have nicknames. My guess is O'Keefe was on the ground. The dog was scratching at his arm while barking or something. Yeah, I don't know. It was... Like I said, there's no... I don't know if we're ever going to know. I don't think we're ever going to know at this point. And that's just the nature of things. So where are... This matches up real well with the defense opening statements, yeah. Well, we would need a tool... Yeah, but we'd also probably need a tool mark, or not a tool mark, but a wound specialist. So, we'll see.
So, jurors, I can assure you that by Monday, we're in really good shape. It's an organizational situation that I have to deal with. So we've been dealing with that. We appreciate your patience, and we are in good shape. And Ms. Gianetti, if you need the exhibit, it's here.
Terrific. May I have it published again on the camera?
Yes.
Now, Lieutenant, with regard to the injuries that you observed, did you notice any lividity on the body when you were looking at John O'Keefe?
Being hypothermic, he was very pale overall. So the skin wasn't pinked up yet. So it's hard to really judge the rest of the skin that way until it's warmed up and much later into the scene.
You are familiar with the term lividity, though?
Yes.
Could you just explain that to the jury?
That's like bruising. So it's like the pooling of blood in lower sections. So for like a cardiac arrest patient, when they have lividity, it looks like bruising on the underside where all the blood has pooled. And we did not really notice that.
But it's not actually bruising from an injury. It's just the blood
settling down. It's the same thing, yes.
One at a time, please.
Yep, sorry. It appears like bruising, and bruising is basically pooling of blood under the skin. So lividity is just gravity-fed pooling of blood under the skin. And it usually happens what is the section of the body that is lowest.
I see. Okay. Now, with regard to the scratches that you've testified about and that you now observe on Exhibit 382, I believe, and you'll correct me if I'm wrong, but I believe your testimony on direct examination was that you observed them in the forearm area, correct?
It was the right, like forearm to arm. I was trying to signal like right up here, but yeah.
Oh, all right.
Yeah.
I guess that's my point.
Yeah.
It wasn't just on the
not just, it was the arm area. Mostly what I noticed was forearm, but there was some around there.
Okay, so it wasn't just below the elbow?
It was not just below the elbow.
There was some above the elbow as well?
Yep.
That's consistent with Exhibit 382?
Correct.
I missed that moment, Your Honor.
Yes.
No further questions.
So, Lally, anything further?
No, Your Honor.
All right, Lieutenant, thank you very much. So you're all set.
Oh, wow.
Our next witness, Mr. Lally.
Yes, Your Honor, the Commonwealth would call Mr. Daniel Whitley to the stand.
Watch your step. Clerk, and read your written hand, please. You solemnly swear the evidence given in the court and during the case now and hearing to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, sir.
Good afternoon.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name?
Daniel Whitley, Whitley.
And what do you do for work, sir?
I'm a paramedic firefighter with the Town of Canton Fire Department.
And how long have you been a member of the Canton Fire?
I was hired in March of '06.
And prior to that work with the Canton Fire Department, did you work within that same field in any other capacity for any other company?
Yes, correct. I worked for American Medical Response out of Brockton as an EMT intermediate and a paramedic for 5 years.
And you're a certified paramedic, is that correct?
Correct.
And how long have you held that certification?
It was, I believe, November of 2006 that I got that certification.
And is there any sort of continuing educational component or recertification process that's involved with being a certified paramedic?
Yes, we recertify every 2 years. We're required to hold basic life support card, which is just generally CPR, and advanced cardiac life support, which is ACLS. It's more dealing with EKGs and how to run resuscitations, cardiac arrests, things of that nature.
Now, sir, if I could turn your attention to January 28th into January 29th of 2022, were you working with the Canton Fire Department on those dates?
Yes.
What kind of shift were you working?
24-hour shift, 8 a.m. to 8 a.m.
And where were you assigned on that particular day?
The Ponquag Station, Station 2.
The Ponquag Station, where is that located within?
The north side of town on Southmont Street.
And how were you assigned to a specific duty or a specific?
Yes, I was assigned to Ambulance 2 with Jason Becker. I was a field training officer at that point, and he was just finishing up his field training after he recently became certified as a paramedic.
And now, at some point shortly after 6 a.m., were you aware of a call or dispatch in regard to Station House 1?
Yes, we had just returned from a previous call about 5 a.m. and heard the tones go off. Actually, we were in the day room, which is where it's the living room of a fire station. And we heard the tones go off. We heard the police going to Fairview Road. And we just kind of sat and were wondering what was going on there.
Now, you yourself, you and firefighter Becker, were you dispatched to a call as well, approximately 6:41 or 6:42 a.m.?
Yes.
And at the time that you received that dispatch, what, if anything, were you aware of with regard to the prior call that the other ambulance went?
So when the tones go off between the two stations, we're able to hear what the dispatch complaint is, what they're going for, and it came in as, I believe, CPR in progress in the snow or something to that regard. So we knew that it was a fairly serious call that Station 1 had gone to.
Now, when you received your dispatch at approximately 6:42 a.m. or so, what was that call in regard to, and where did you respond?
We were dispatched for a Section 12.
And as far as your assignments within the ambulance between yourself and firefighter Becker, with regard to this call, who was doing what?
I was driving. He's what we call the tech, the lead paramedic on the case. That's just generally how we operate.
And from your response, or you're driving from Station 2 to Fairview Road, what, if anything, did you observe or experience en route in between the two?
At that point, it was snowing pretty heavily. We were coming down Chapman Street, getting ready to take the right onto Fairview. We nearly slid off the road, making the turn onto Fairview. It was snowing that heavily, and I don't believe the roads had been really plowed or treated or anything like that for us to, so it was pretty slippery.
Now, in addition to ambulance number 2 that you and firefighter Becker were in, what if any other sort of vehicles or apparatus was dispatched to this call as well?
There was engine 3, which is the District 1 engine, and at least 2 police cruisers. And then another gray SUV kind of further down from where we parked.
Now, when you arrive in this area on Fairview Road, what if anything do you sort of observe as far as who's there when you arrive?
When I got out, my Lieutenant Woodbury and Sam Park were there.
And they were on the engine, is that correct?
They were on the engine, correct.
Now, beyond sort of the personnel from your department, you mentioned that there were some police officers there as well?
Yes, Melanie and Sarah, and then 2 other females, at least 2 other females.
And the other 2 females, where were they when you first sort of get out of the ambulance?
A few yards ahead of us, a few dozen yards ahead of us, I'd say.
And were there any other vehicles beyond sort of first responders that you observed on?
Just that other gray SUV.
And so I guess my question is, where were the 2 females that you observed in relation to the gray SUV?
Near it, maybe in front of, maybe one was inside. There were 3 females there.
And at some point while you're on scene, you learned the identity of your patient, correct?
Yes.
And what was the name of the patient?
Karen Reed.
And you had some conversation with Karen Reed that day, is that correct?
Yes.
And do you see Karen Reed in the courtroom?
I do.
Could you just describe as to where she's seated or an article of clothing that she's wearing?
She's seated right at that table right there.
I'm sorry, if you could just point as to where she is.
Right here.
No, I just asked record reflect identification.
Okay.
Now, when you first sort of arrive on scene, who, if anyone, is the first person that you talk to?
Lieutenant Woodbury and Sam Park.
And following that conversation, who, if anyone, you speak to?
Probably briefly Lieutenant Mulaney, but more, Officer Mulaney and Officer Sarah.
Now, following your conversation, well, let me ask you this sort of in general terms. When you respond to a call for a Section 12, what is sort of the protocol that you go through in regard to that?
Whether it's a Section 12 or any call, basically, the lead tech generally takes over immediate patient care, goes over, assesses. Usually the partner will go over and try and find out background details, try and find not only, well, especially for a Section 12, you want to get, the tech will get, which is Jason's role, the patient story, and then I'll get everyone else's story.
And at some point, you have a conversation with Ms. Reed as well.
Oh, yes.
And where is that in relation to vehicles on scene? So what is that initial conversation?
The initial conversation, she was very upset. She kept saying, so we had a Section 12 written, and that was to take her to the hospital because she made threats against her life, saying, I don't want to live anymore. If my husband dies, I don't want to be alive anymore. And myself and Jason and Lieutenant Woodbury were kind of like, well, that's seemingly more in the lines of normal grieving process after something traumatic happens to a loved one, whether they're going to die or not. We kind of didn't feel like it kind of led to that level of a Section 12 to have her transported to the hospital. So at that point, I exited the ambulance and I went to speak with Officer Saraf, and I said, this kind of doesn't if we want her to be at the hospital, get a full eval, we're going to need more than just, if my husband dies, I want to die, because that seems just like normal grieving things to say. And so I went back to the ambulance. He went, I don't know where he went. I don't know whether it was cruiser or what, but he came back, notified me that her
Sustain.
And from that conversation, did you receive more information or more clarity as to statements that Ms. Reed had made?
Yes, Officer Sheriff had said that.
Objection.
So not what he said, sir. So
We
you
were
are
informed
unmuted.
that,
Objection.
I'm not sure.
So you can't testify to what somebody else told you. You can when there's no objection regarding what Ms. Reed told you,
Okay.
but you can't testify what anybody else told you.
Okay.
So when I say sustain, that means you have to stop. And,
Okay.
and the lawyer will ask another question. Okay. Thank you.
Thank you, Your Honor. So, Firefighter Willoughby, at some point, specific to your conversations with the defendant, Ms. You described sort of her demeanor, any observations you made in relation to that as you were speaking.
Yes, she was very upset. She kept asking if there was any chance. She kept asking us if we knew if the person ambulance 1 had transported was alive or dead, and we could not speak to that. She asked if somebody could be alive in the snow without a jacket for many hours. And at that point, we were just trying to give her any hope that whomever A1 transported was still alive. And we kind of just talked about far off hypothermia cases where, kids have fallen in rivers and been submerged for many minutes, maybe even hours, and survived with no neurological deficits. So we were just trying to give her some sort of hope on the way to the hospital that there was a chance that her husband could be alive.
Now, at this point, what, if anything, did you know about sort of the relationship between your patient, the defendant, Ms. Reed, and the patient from ambulance 1 that had been transported previously?
She identified him as her husband.
And is that something that she said once or more than once?
Many, many times.
Now, she asked you some questions about his status and made specific reference to his clothing. Is that correct?
The only thing I recall is asking if he could have survived without a jacket.
Now, as far as these conversations that you had with Ms. Reed, where did they occur in relation to the ambulance?
They were in the back of the ambulance.
And who, if anyone, was present in the back of the ambulance beyond yourself and the defendant?
Jason Becker.
And with reference to, you mentioned that firefighter Becker was sort of the lead paramedic or the lead tech on this, is that correct?
Yes.
So is there, from sort of his role and your role, what are some of the sort of differences in the duties and responsibilities in relation, we'll call it?
So for any Section 12, our department policy is there will be 2 EMTs, paramedics, firefighters with during transport at all times. That's both for our safety and the patient safety. So that's why it wasn't just 2 EMTs or paramedics driving to the hospital. I was in back with Jason, and Sam Park was driving.
Now, as far as you testified earlier about observations of her being upset or distraught, is that correct?
Correct.
Was that consistent throughout your interaction with her, or?
No. There would be episodes where she would go from crying in her hands to all of a sudden perking up. She was crying about having to take care of kids, saying she couldn't do it. And I was saying, you can do this. It's not as hard as it seems. She kept saying, I can't take care of these kids. They're not my kids and they're not his kids. That's when I figured out who ambulance 1 transported. And I was saying, well, it seems like you have a good, strong support system. People who came and helped you in a blizzard to help come find your husband. She said, she asked me if I knew Carrie Roberts. I said I did. She said anybody who knows Carrie Roberts wouldn't say those things. And that kind of took me aback a bit. It seemed strange to say something like that after you were just crying because your husband was dead.
Take you back to within.
I was just kind of surprised.
If I could take you back within that just for a minute. So you had testified that during that, her description, you sort of realized who was a patient in ambulance 1, is that correct?
Yes.
And what, if anything, made you realize, or who did you think it was?
I live in and grew up in the Ponquag neighborhood of Canton. And Mr. O'Keefe was known for taking on his niece and nephew after, I'm sorry, I'm not sure positive of the relationship, but I believe it was his sister and his brother-in-law passed away. And it was something people admired him for, people looked up to him for. But I was able to, I also, I moved into the Ponquag neighborhood back after living outside of Canton for a few years. The O'Keefes lived diagonally across from me. I never had any sort of interaction with him or anything. When I moved in, my wife was probably about 6 months pregnant and I had 2 toddlers, so I was pretty busy. I figured he was pretty busy. I never even had a chance to introduce myself or anything before he moved to Meadows, which is how I kind of figured out.
Your Honor, I object to this line of question.
Okay, next, sustain. Next question.
Now, you had also mentioned during your conversation with the defendant that she had said some things about Carrie Roberts, correct?
Correct.
And how is it that you know Carrie Roberts?
Well, Carrie lives around the corner from me.
Objection.
No, I'll allow that. Next question, please.
How long have you known Carrie Roberts?
Just from moving back into the neighborhood, she would run the neighborhood block party, and she put out that she would like the fire truck there on the neighborhood Facebook page. So I volunteered to bring the fire truck to the neighborhood block party.
And was Ms. Roberts seen on Fairview when you arrived in your ambulance?
Yes.
So she was one of the other females along with the defendant?
Correct.
Now, with reference to when you brought up as far as support system, and included Ms. Roberts within that, what, if anything, did the defendant say about Ms. Roberts?
Objection.
Sustain. Next question, please.
This conversation that you had with the defendants in the ambulance, about how long a period of time were we talking about?
20, 25 minutes.
And beyond what you've already testified to, what did sort of that conversation consist of, or what was the sort of tone and tenor of that conversation?
Again, we were just trying to give her any support. She was, once we were getting closer to the hospital, we
Objection.
So the tone and tenor. So what can you tell us about that? That's admissible, Mr. Yannetti. Go ahead.
The tone, she would go from being almost despondent to when she asked me if I knew Carrie Roberts, the only tone I can use to describe it is snarky.
Objection. Move to strike.
I'll strike that.
Now, You transported to Good Samaritan, is that correct?
Correct.
And when you, during the transport, where are you in relation to Ms. Reed from Fairview to Good Samaritan?
I'm sorry, I don't understand.
During the transport, Ms. Reed is where within the ambulance?
I believe we have what we call a tech bench, which is a long bench. There's the ambulance stretcher, and then next to the ambulance stretcher is, we call it the CPR seat. And then that's where Miss Reed sat. And then I was in what we call the airway seat, which is basically like a captain's chair behind the stretcher.
And in addition to yourself and the defendant, who, if anyone else was.
Chad, I can't do this.
During transport, it was just
Can't do it.
me, Jason Becker, and Miss Reed.
With the Boston
So
accent.
yourself
Oh my
along with
God.
Firefighter Becker and, correct?
Correct.
Who was driving you?
Sam Park.
Now, when you arrived at Good Samaritan, what, if anything, happened?
Miss Reed was asking to be able to see John, and I made the decision that I would run ahead to see if that was in the realm of possibility with the emergency room physician there. So I ran ahead. I came into they call it the code room at Good Sam, and I asked if the wife could see the husband. The ER doctor asked if she would be upset. I said if she would be upset if she was allowed to or not. And I said she's going to be upset. I believe she's going to be upset either way. He was asking if she would get in the way of the resuscitation efforts. And I said it's possible. She's very upset.
And so once you arrive at the hospital with the patient, where do you go along with Ms. Reed?
We escorted her down to we call it the psych hall or the behavioral hall at Good Sam.
And about how long was it after you escorted her into the hospital that you stayed with her following that?
At least 10 minutes.
And during those 10 minutes, how would you describe sort of her behavior or demeanor during that time?
Objection.
No, he can testify to that.
He was giving the nurses a hard time about, I'm sorry, she was giving the nurses a hard time about having to get into a Johnny, about having to submit a urine sample. Even the AR techs went to the physician who was in the code room to see if she could not have to wear a Johnny, and the ER doc said no. If she's in the psych hall, she's a psych patient, needs to be in a Johnny. So at that point, there was just a nurse and a tech. We don't usually leave a psych patient with just a single nurse and a tech. So we decided to wait until security had gotten there before we left.
May I have one moment?
Yes.
Nothing further at this time, Your Honor. Thank you.
All right, Ms. Giannetti.
Thank you. Good afternoon, sir.
Good afternoon.
So, Mr. Whitley, when you showed up, you learned that Karen Reed was the patient that you were to deal with, correct?
Correct.
And it was your expectation that she would be going to the hospital, correct?
Correct.
One of the things that you do when you transport somebody to the hospital is you try to get a medical history, correct?
Yep.
Why is that important?
Generally, we get pertinent medical history to pass on to the hospital. So if something were to happen where the patient wasn't able to describe their past medical history, it gets passed on to the next caregiver, which would be the nurses, doctors at the hospital.
More information is always better than less information, correct?
I would say so.
And with regard to Ms. Reed, did you take a medical history from her?
I assume Jason did.
Okay. Did you learn the results of that medical history?
You'd have to refer to Jason's report.
I may have a moment now.
Yes.
May I approach?
Yes.
Mr. Whitley, if I, I'm actually going to show you two documents with your permission. One would be Jason's report.
Okay.
And you talked about Jason Becker, correct?
Correct.
The other is a police report from Sergeant Yuri Buchnick. I'm going to give you the second page of that.
So let's do them one at a time.
Sure. And you've asked for Jason Becker's report, so I'll give you that first, okay?
Okay.
And when I approach you, I'm going to hand this to you, and I just ask you to look at it silently by yourself.
Okay.
And then look up at me when you're done.
Okay.
I'm going to collect that from you if you don't mind.
The first report was the NFIRS report from my lieutenant.
Was Jason Becker's report included in it?
Yes.
as well?
Yep.
Having reviewed those documents, does that refresh your memory as to the medical history that was taken?
Yes.
And what can you tell us about that?
Just lists multiple sclerosis.
What is multiple sclerosis?
I believe it's a neurodegenerative disease where the myelin sheathing of the trying to think of the word here, but
I don't mean to put you on the spot.
no, I understand.
I'm sure you do. It's a disease.
It's a disease that's progressive and has neurological muscle control things involved with it.
And when you say progressive, that means it gets worse over time as you age?
As I understand it.
And that was the medical history you got from Karen Lee?
Correct.
I'm nothing further.
All right. So, sir, you are all set. Thank you, Mr. Whitley. Your next witness, Mr. Lally?
Yes, Your Honor, we'll call Mr. Jason Becker to the stand.
Please watch your step. Face that clerk, raise your right hand.
Do you solemnly swear the understanding of the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God?
Okay, whenever you're ready, Mr. Lally.
Thank you. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
First name is Jason, last name is Becker, Becker.
And what do you do for work, sir?
I'm a firefighter paramedic, Canton Fire Department.
And how long have you been a member of the Canton Fire Department?
5.5 years.
And prior to that, what, if any, other employment did you have sort of within that same field?
I worked at Found Ambulance and South Shore Hospital.
How long did you work at each of those respective positions?
Found Ambulance was about 5 years. South Shore Hospital, approximately 3 years.
And with regard to South Shore Hospital, what is it that you did there?
I was a nursing assistant in the emergency room.
And with regard to your work as a firefighter paramedic for the Canton Fire Department, you were a certified paramedic?
Yes.
And when did you first receive that certification?
October 2021.
And is that something that you receive, or when you receive that, is something that goes on in perpetuity, or is that something that you have a continuing educational component or recertification?
Con Ed education, every 2 years you have to recertify.
Now, sir, if I could turn your attention to January 28th, 2022 into January 29th, 2022. Were you working on that occasion?
I was.
And where were you assigned? I'm sorry. What type of shift were you working on that occasion?
What type of shift?
Yes, like what hour to what hour?
8 a.m. to 8 a.m., 24 hours.
So 8 a.m. on the 28th until 8 a.m. on the 29th.
Correct.
And where were you assigned on that day?
I was at Canton Station 2, Ambulance 2.
And who, if anyone else, was assigned with you to Ambulance 2 at Station 2 on that day?
Daniel Whitley, firefighter Daniel Whitley.
Now, at some point when you were working on the 29th, shortly after 6 a.m. or so, did you become aware of a call for station house number 1?
Yes.
And what, if anything, were you aware of as far as that earlier call?
As far as a man down in the dispatch, and I believe it was upgraded eventually to CPR in progress.
Now, at some point following that, approximately 6:41 a.m. or so, did you, your station house get a?
Yes.
And what that dispatch in regards to?
A psych eval, possible section 12.
And in addition to yourself and firefighter Whitley in Ambulance 2, what, if any, other sort of vehicles or apparatuses were dispatched by your department to that call as well?
Canton Engine 3.
And if you know, who, if anyone, was on Canton Engine 3 at that time?
Lieutenant Greg Woodbury, firefighter Sam Park.
Now, with regard to the ambulance that you were in with firefighter Whitley, what were sort of let me ask you this, between sort of call volume, what, if any, sort of policy or protocol is there as far as who does what on a particular call?
We switch off.
And so on this particular call that you were dispatched to Fairview Road, what were sort of each of your respective duties and responsibilities between yourself and firefighter Whitley?
Firefighter Whitley was the driver at that point, and it was my tech is what it's called. So the next patient would be mine.
And so as sort of the lead tech on this, is that correct?
Correct.
And so as far as the lead tech's role, what, if any, duties or responsibilities do you have in regard to writing a report?
It's my report. That'd be right.
May I approach the witness?
Yes.
Only with documents just have to review that with us.
The first report up here is the engines. Second one would be mine.
You recognize the first few pages of that as the engines report, and the last few are yours, correct?
Correct.
And that's your report with relation to this dispatch and this call, correct?
Correct.
May I approach again, Your Honor?
Yes.
I want to seek to introduce and admit as the next.
So both reports through this witness? Is there any objection?
May I just take a look at the DA's copy? where we approach.
Okay. Bless you.
With that addendum, I would seek to introduce and admit that as the next exhibit.
Okay.
And Your Honor, with the court's permission, can I return the report to the witness?
Yes.
Yes, Mom. Now, sir, when you first sort of arrive in the area of 34, when you arrive in the area of Fairview Road, what, if anything, is it that you first observe upon your arrival?
Coming down the street or on scene?
Yes, coming down.
Coming down the street, just live police lights. You can see the fire engine, and which I believe I said it's one black SUV.
And where is it that you and the ambulance sort of parked in reference to those other vehicles that you see?
I believe we parked. If the SUV was facing towards us, we parked to the left. I don't recall where the police cruiser was, though.
And when you first arrived there, who, if anyone, is it that you first speak with when you get there?
When we got out of the ambulance, I passed Officer Saraf and Officer Mulaney. They kind of briefed us, and then I walked over to the black SUV.
And when you walk over to the black SUV, who is it that you observe in that black SUV?
I saw two females.
And of those two females, do you see one of them in the courtroom today?
I do.
Could you just identify as to where she's seated or an article of clothing that she's wearing?
Right over there, the jacket on.
That's the record of like identification.
Okay.
Now, with respect to the defendant, Ms. Reed, where within the vehicle is she when you first come up to the vehicle on foot?
What I remember, she was in the front passenger seat.
And what, if any, knowledge that you have as far as the defendant, Ms. Reed, and her relationship to the earlier call that ambulance one had been dispatched?
Very little. I think we had gotten briefed that she was the wife of the previous patient.
And was that something that she had stated or something that somebody else had stated? Where does that awareness come
I
from?
believe it was one of the Canton police officers that said it.
I'm sorry, what was that answer?
It was one of the Canton police officers.
Okay.
And so when you walk up to the car, what is it that you say to her? What, if any, conversation did you have with Ms. Reed at that?
So I went up to the window and introduced myself and just kind of asked what was going on.
And how did she respond to that?
She was kind of, she was distraught. She was crying. She kind of told us that the statements she may have made, she didn't mean it because of the events that she had just gone through.
What, if anything, did she say about that? If anything, did she say about what she had gone through?
She had just done CPR on her husband.
And so she referred to him as her husband as well.
Yes.
And this conversation that you had sort of at the side of the SUV, is that through the door, through the window?
From what I recall, it was through the window.
And at some point, does the conversation move to the ambulance?
Correct.
About how long was the conversation at the vehicle before the conversation shifted to the ambulance?
5 to 10 minutes.
And as far as your dispatch for a psych or a section 12, correct?
Correct.
Can you explain to the jury sort of that process, just in general terms first, as far as what does that process entail?
And when we get on scene?
Yes.
For a section?
Yes, please.
We go on scene, we kind of look at the environment, see what the environment's like, see if the patient's cooperative, uncooperative, what their demeanor is, if there's any obvious self-harm. If there's none, we kind of go up and talk to them, get a report, and ask them some basic triage questions.
And is that sort of the policy or the protocol or what you followed in this instance with Ms. Reed?
Correct.
Now, beyond what she had indicated to you initially, what, if anything, was she asking you during the course of your conversation with her once you were in the ambulance?
She kept asking if he was dead or could he be dead?
Is that something that she said once or more than once or something?
More than once.
And could you describe sort of the tone of her voice when she was saying?
It was pretty, it's kind of like it was a rapid kind of pressure speech. She was just a lot repetitive.
And as you were speaking with her, what, if any, observations did you make of her facial area?
She had blood on her face and her neck and her mouth, her neck and chin.
Regard to sort of any earlier suicidal statements, what, if anything, did she say in relation to that?
She said she made him because she just went through traumatic events, seeing her husband dead, and she had no plan on acting on it.
Now, pursuant to a Section 12 call, what, if anything, are you doing as far as documentation goes with respect to vital signs, things like that?
It depends on the situation. In a situation of misreads, I took a regular, just vital signs, pulse oximetry to see her heart rate. But for someone like a female psych patient, it's more verbal.
And as far as any of those sort of vital signs and things that you took, what, if anything, abnormal did you note in regard to that?
There's nothing too abnormal. Just the heart rate might have been a little bit high, but within normal range.
Could you please keep your voice up, sir? Thank you.
Sorry. But the vital signs, her heart rate was a little high, it was 98, but it was nothing concerning.
During the time that you're having this conversation with her in the back of the ambulance, how would you describe her demeanor?
She would have periods of calmness, and then other periods she would appear agitated because she didn't want to go to the hospital. But all in all, she was cooperative with us.
Now, at some point, she's cooperative, correct, and agrees to go?
Guys, sorry.
Eventually, yes.
I had to step away for a
You
minute.
say
My
eventually, was
apologies.
there some conversation related?
We kind of mentioned to her basically what
I've
a
been
Section 12
listening
is.
on my phone.
Yeah, and unfortunately, she'd have to come with us involuntarily.
So you're explaining the process to her, is that correct?
Correct.
Eventually, she agrees to go, correct?
Correct.
And as far as the transport goes, who, if anyone, is in the back of the ambulance with her during the transport?
Me and firefighter Whitley.
And who, if anyone, was driving the ambulance to the hospital?
Firefighter Park.
And which hospital did you transport Ms. Reed to?
We went to the Good Samaritan Hospital.
Now, during the course of transfer to the hospital or transport, What, if anything else, did Ms. Reed say with reference to children?
She was talking about children. She wasn't sure, and she didn't know if she'd be able to take care of them. She was worried about that.
She was worried about that.
Yeah, she's worried about who would take care of the children if he was pronounced dead.
And what, if anything, did she say about herself in reference to the children?
She didn't think that she could take care of them on her own.
Now, as far as this other person or the patient from the earlier call, how did she refer to that person in relationship to yourself?
She was calling him the husband.
Now, with reference to this particular, with reference to Ms. Reed in this conversation, what, if anything, did she say in regards to the last time that she had spoken to who she called her husband?
She had said that they had gotten into an argument. She was sad because that was the last thing she had said to him was the argument, but she didn't go into detail on what the argument was about or what was said.
Now, with regard to her speaking about children, what, if any, further conversation did either yourself or firefighter Willoughby have with her in regard to that?
With children?
Yes.
I don't recall.
The other female party that Ms. Reed was initially with in the vehicle when you first arrived, did you know who that was?
I don't know who she was.
And at any point in time, subsequent to that, did you learn who she was?
I did.
And who did you learn her to be?
She was Ms. Carrie Roberts.
And with relation to your conversation with Ms. Reed on that day of January 29th, what, if anything, did she say about Ms. Roberts?
Objection.
Sustained.
The regard to the sort of medical questions that you were asked, from those medical questions, what, if any, questions would you typically ask someone with relation to consumption of alcohol or drugs?
Well, probably part of the psych assessment, I asked if she had taken any drugs or alcohol, and she had denied it at that point.
She said that she had not, correct?
Correct.
The observations that you testified to earlier in regard to her, and by her I mean Ms. Reed's demeanor, did that change at all during the course of your interaction with her, or was that consistent throughout?
Demeanor as in?
It's a poorly phrased question. I'm going to try and rephrase it. So with regard to her demeanor, throughout the course of your interaction with her, how would you describe that?
She was cooperative. Then she'd be calm, and then eventually she would kind of get a little agitated and repetitive questions. But she seemed distraught.
Who wouldn't get agitated with
With
repetitive
respect
questions?
to
I
the
mean,
person
let's be
she
real.
indicated was her husband, what, if any, questions did she ask you or firefighter Whitley or both in relation to him?
She was asking if he was dead. Or could he be dead? Could he be dead? And she said, could I have hit him?
Was that something that she asked once or more than once?
It wasn't a lot. It was more of could he be dead? Could he be dead?
So somewhat repetitive, is that correct?
Correct.
Just one moment, Your Honor.
Yes.
I mean, nothing they've said so. I mean, I'm just really concerned because basically, yeah, why would she ask that? Number one. Number two, all it takes is for you to suffer a loss in front of this fire department. Someone in your family dies, they're going to take you to the fucking nut hut?
Firefighter Becker, just my own clarification. You testified earlier that first arriving on scene and first spoke with Ms. Reed, she indicated that there was some statements that she said there were some statements that she did not mean, correct?
Correct. Suicidal statements.
And so, exactly. So my question is, that was in reference to the suicidal statements she had made prior to your arrival, correct?
Correct.
Not to any subsequent statements, correct?
Correct.
Nothing further.
All right, cross-examination.
Thank you, Rona.
Yeah, they just
Good
blew up their
afternoon, sir.
own
Good
thing
afternoon.
here.
You and I have never met, right?
I believe so.
I wanted to go back
I mean,
to
this isn't very damning for her either,
one
though.
piece of testimony that you offered on direct examination, if I may.
Sure.
You had, in response to a question from the prosecutor about the medical history and your question to Ms. Reed about whether she had had any alcohol.
I mean, yeah, it kind
to
of looks
drink.
like
I
that.
believe your answer today was she denied having drank alcohol the night before.
As at the time that she was, she could have. I don't know if she drank alcohol the night before, but at that time, I asked if she had any drugs or alcohol, and she said no.
I'm sorry, if I just didn't hear.
Yeah,
that.
you need to keep your voice up, sir. Speak
Okay.
directly into
Sorry.
the microphone.
I asked her if she had any drugs or alcohol, and she said no.
Oh, if she had any drugs.
Well, if she'd taken any drugs or alcohol, she said no.
Did you specify a time period?
I just assumed it'd be in the last few hours for the reason why we were there.
Oh, I see. Okay.
Unsure if she had alcohol days prior, but for the reason why we were there.
Okay. So was it your understanding that the two of you had an understanding of what you were asking?
Sure.
Objection, move to
Yeah,
strike.
yeah. So the objection sustained. It's stricken. Ask the question differently, Ms. Giannetti.
Thank you, Your Honor. All right. So I guess with regard to your intent and your state of mind when you were asking that question, you were asking, had you taken any drugs or alcohol within the last few hours? That's what you meant to ask?
Objection.
So the objection sustained.
What did you specifically ask?
So when I ask a patient if any drugs or alcohol, I'm talking about at that point in time, but an hour before, 2 hours before, not days before, weeks before.
Okay.
So-
And this was at 6:40 in the morning?
Correct.
Did you smell any alcohol on her at that time?
I did not.
Okay. You would agree that she did tell you at some point that she had had alcohol the night before, correct?
No.
All right. So this is now, what's today, May 3rd of 2024?
Correct.
And this happened back in January, on January 29th of 2022?
Correct.
You were interviewed by a Trooper Michael Proctor on February 14th of 2022. Do you recall that?
I recall meeting with him, yes.
And February 14th of 2022 would have been a little bit more than 2 weeks after January 29th of 2022, correct?
Correct.
Your memory of what Karen Reed told you about whether she had anything to drink the night before would have been much better on February 14th of 2022 when you were talking to Trooper Michael Proctor than it would be today, correct?
Correct.
Because your memory doesn't get better over time, correct?
Certain circumstances, sure.
And with regard to whether Karen had indicated that she took any drugs, you told Trooper Proctor she said that she had not, correct?
Correct.
With regard to whether she had had alcohol the night before, you told Trooper Proctor on February 14th of 2022 that she did consume alcohol last night, correct?
Objection, Your Honor.
All right, I'm going to see at sidebar on this. Please bring that with you, please.
Well, why are we doing that? Come on. I think they've got a valid for what they're doing here. This makes entirely perfect sense. I don't. This is just. I'm not, some people are wondering, is this hurting here? And I'm like, not as bad as these lying firefighters are hurting.
With your permission, I'll repeat the question.
Sure.
You told Trooper Proctor on February 14th of 2022 that Karen had told you that she did consume alcohol the previous night, correct?
If that's in his notes,
Is your memory exhausted as to whether you told him that?
I don't recall.
If you saw his report with your statements in it, would that refresh your memory?
Sure.
It's a two-page report. I'll give you both, actually. It's a two-page report. I'll give you both pages, but I have highlighted a line on the second page, so I would direct you to that. May I approach?
Yes. And take your time reading it, sir.
Yes, yeah. And please read it silently to yourself and look up at me when you're done.
Let's see what happens. I don't know, guys. This is. They have no vested interest, but why are they incorrect? That's an issue. I mean, they have a vested interest, like, well, the town, keeping your job. I mean, there's a multiple ways you could spin that.
So I did say.
So, Mr. Becker, a couple of things. Wait for a question.
Oh, I'm sorry.
But also, you have to keep your voice up.
Okay.
I'm close to you and I'm having trouble hearing you. Most of the jurors are further away.
And the way this works is I have to collect that from you and then ask you a question, okay?
Sir.
I may approach you on.
Yes.
Having reviewed that document, does that refresh your memory as to whether or not Karen Reed, or strike that? Having reviewed that report, does that refresh your memory as to the fact that
Does that refresh your memory?
Does that refresh your memory?
It does.
Okay. And so did you tell Trooper Proctor on February 14th that Karen Reed had told you on January 29th that she had consumed alcohol the night before that?
Sure. Yes.
Okay. Is it fair to say that when you were listening to her talk at times, that her speech was very rapid?
Correct.
And particularly when she had said the words, is he dead? Is he dead? She would repeat it repetitively, correct?
Correct.
And she was fixated on that, correct?
Correct.
And with regard to the last interaction that she spoke about with whom you thought she said her husband, she didn't give you any detail about that, correct?
She did not.
You don't know whether it was an in-person communication?
That wasn't my position to ask more details about that.
And I'm not criticizing you, sir. I'm just trying to get to what your knowledge was in terms of
Right.
information you got from her. So she didn't specify that it was an in-person communication, correct?
No,
She didn't specify as to whether it was a phone conversation?
she did not.
She didn't specify whether it was a text message exchange back and forth?
She did not.
And she didn't specify whether it was an angry voicemail that she left, correct?
She did not.
That sounded crazy.
No further questions. Thank you.
Does she
Just
sound
one moment,
crazy?
Okay.
Knew they're gonna let a. We'll see what redirect gets us.
Sorry.
I have nothing further for this witness, Your Honor.
All right. All right, Mr. Becker or Firefighter Becker, you are all set, sir. Thank you very much.
Sorry about that.
That's
Interesting.
okay.
No
Thank you.
redirect. That's very interesting.
Yes, you can leave that right where it is. Thank you, sir. Your next witness, Mr. Lally?
May we approach?
Sure.
So, I mean, was anybody like, "Oh my God, Karen's guilty"? Because I'm not. Yeah, guys, I'm not there. I'm not there. So wait to get to the can, please. Chief is out on leave. Finds the broken taillight days later. Ah. That'll be interesting. She was wearing a thong. Fox says we all say incorrect shit, but it's everybody. That's part of the problem here. No vested. They're all fucking up. All these firemen, they're in charge of us. And they're like, burp, 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 burp. I just don't know what done been said. Ooh, I'm goofy like that. Ha, 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 ha. It's like, that's not good.
Does it make sense that rather than starting with another witness, I figure it's a Friday afternoon, it's been a long week for you all, we'll excuse you at this point. So please do not discuss
I don't know who
this
Trooper
case
Proctor
with
is, but I
anyone.
can't wait to
Don't
hear that
do
interview.
Any independent research
Or
or
take the stand.
investigation into this case. If you happen to see, hear, or read anything about this case, disregard it and let us know. Have a great
Disregard
weekend.
it.
Monday will be a full day. We'll see you first thing Monday morning.
Oh, and the funny thing is Monday, I've got court, so I won't be here Monday, sadly. 362 people watching on YouTube. Thanks for being here, guys.
Oh, sure.
The Nick Ricada method.
May be seated.
I think there's an exhibit in the witness stand. All right, because I've decided that it makes more sense to do exhibits the old-fashioned way because it's simply not working out. My suggestion is that we take what we have that have actually been introduced because I know you pre-marked nearly 600 exhibits. They have not been introduced into evidence. So we have numbers 1, 2, 3, 4, 7, 8, 9, 14, 18, and there are additional that are in the 300s and 200s. So what I would like to do is take all of these, and I know Madam Court Reporter has been great about sticking around all late during the week to pre-mark things. This is more important to me that we get the record straight from this point. I would prefer the jurors to have the exhibits in order and not have numbers 200 and 300 in where they should be 15 and 16. So what I would like you to all do is take a look at the exhibits that have actually been introduced. Their prior numbers. If you have referred to them by their prior numbers, I will permit you for the rest of the trial to say previously referred to as 308, but now Exhibit 15, until you feel you
You
don't
can
need
go
to do
after
that
them.
anymore.
Just
So it means
remember,
things are going to
you
have
fight
to be
me at.
renumbered. So, Madam Court Reporter, was there anything else we needed to discuss on this?
Arguing
Is there
over the
anything else
court
you need from the lawyers?
exhibits. That's not.
Okay. So I don't want to use your name. You've got a list of everything, and Mr. McDermott's got a list of everything that's been introduced. Do you need me to do this, or is this something you can all do with Madam Court Reporter? And I want to come out and make sure it's right. All right, so why don't you all take 10 minutes to see if you can work this through. I'll come out at the end of 10 minutes, see what you have, and we'll make sure the record's straight. Does that make sense to everybody?
It does. The only thing that I would ask to add to that, Your Honor, is in conformity with the court's ruling as far as redaction to the run sheets and the run reports. I'm not sure if they've been stickered or not, but there are medical records with regard to both the victim and the defendant that would be in there, and I would ask for them to either be marked for identification or taken out at this point. Ms. McLaughlin indicates they haven't been marked yet, so I would just ask to sort of retrieve.
All right, so that's sort of the second point. I assume there are many pages of medical records, and one of the things I told you this morning is if records are going to be introduced subject to redactions, those redactions have to be done before they're introduced. It's going to take some time. So you have to be, if you're not in agreement, then you need to tell me what you're not in agreement over, and I'll have to decide it, but they need to be redacted beforehand. Just because this is a long trial, I don't want it to take any longer than it necessarily has to be. And we have to make sure all of the exhibits are in order, especially if they do end up numbering in the hundreds. So, all right, so you've factor that into your schedule. We've got many days that we won't be in session. It seems like a good use of council's time to redact records and talk. If you need additional time and we need to cut into the evidence, I'd prefer not to, but I need to know. All right. So I have received from the Commonwealth all of the videos that I requested. I received a flash drive today. When can I get the videos? I thought I was clear yesterday. Apparently I wasn't. So when can I get all of the videos that the defendants intend to introduce? I had hoped to look at them over the weekend.
We can do, it's not a matter of getting them onto a flash drive. That's quick. It's just a matter of getting them to the court. So I would invite the court to direct us how, if you want to use the weekend, let us know. We work on Saturdays and Sundays.
So so you can't do it today. You can't do it before you leave. I don't think your IT person's here. Right? Oh, if you can do it before you leave, if he can just download it onto a flash drive, that would be great. Do you want to go talk to him and see how long?
You might be able to do that.
We may be able to do that.
Why don't you talk to him?
Just end it now.
Yes. Yes.
All right.
We won't leave until we give it to you.
That would be great. And Ms. Gianetti, yesterday you did say that you'd also give me some idea on why you think they're coming in.
Sure.
Okay, so if you have that, that would be great.
Yeah.
All right.
You I just want to make sure I'm very clear about what the court would like. We provided the double videos, the ones that we had put the good and Seraph cameras together. The court wants every single video that we intend to produce?
Yes.
For the rest of trial?
Yes.
Okay, understood.
All right, and that's what I requested from both of you. I received, Ms. Gilman, tell me if I'm wrong, but Mr. McDermott handed me a flash drive today that said this was all the Commonwealth's video exhibits. Yes.
And that was after we met this morning, correct? Okay.
All right, so that'd be great. I just, I want to know what's on them. I was surprised yesterday, and
understood.
I shouldn't be surprised.
Understood.
All right, so I'll come out after you remark the exhibits. Do you need a break before then, Madam Court Reporter? Mr. McDermott? All right, thanks.
Court, all rise, please.
What were you surprised about? Like, that's your fault, Judge. It's your fault for not demanding those early enough. I'm just saying, that's stupid. Yes, Daryl Brooks has a court appearance today. We might zip over to that. Doesn't look like there's a whole lot going on.
Hey there, Karen Reed, trial watchers. You know what a lot of the trials we cover remind me?
Yeah, thank you, Jesse. We're not talking to you right now. Yeah, I mean, I'm not. I don't look at this and see Karen's any more guilty. It sounds like they're basically like forcing her into going into the Baker hold and doing a 72-hour hold on her. And yeah, I mean, I don't think it was warranted. So yeah, it seems like everybody's lying and they are all mistaken or something. Now we can't say, oh, well, the one firefighter who tells no lies is correct. Well, that guy's dead. Does he have subject matter jurisdiction? Oh, I don't know if he does or not. Oh. That's how we got a couple of super chats to read through real quick. Unhung Hero for $5 says, I've never heard people lip smack as much as these witnesses. WTA. I think lip smacking more than like Tommy Witherspoon and Friday. And he's got hot sauce on the burrito. Craig's dad and Friday. Unhung Hero for $5 says, want a drink like Nicker? Drink every time a witness smacks the lips. Very true. Very true. Very true. It's I don't know. The needle has not moved for me that way. Is there any reason they have logged the evidence as it goes along? Well, it's probably already been pre-marked, but they have to log how they introduce it when it gets introduced, just to make sure they can control what evidence is made in, made it out. And that's how they do it there. So, I mean, here, that's not how we call it or do it, but we do a similar thing. So it's not really that big a deal. Yawn, yes. Brooks hasn't started. Yeah, it looks like Daryl Brooks is in a wheelchair now, which, couldn't happen to a nicer guy. Let me see if I can show you. Oh. I mean, really. Fort Brooks, you guys want to see Daryl? He used a wheelchair before the hearing. Yeah, well, there's footage of him getting wheeled in. Yeah. So, yes, Daryl Brooks in a wheelchair. We can switch over to that real quick, guys. You could say they grounds him down. Well, speaking of grounds, because it still exists, underneath this pile of Enfield ammunition. You can get your exclusive Brooks Coffee Company out of Waukesha, Wisconsin, serving the relevant ground since 2022 at my merch store down below. They're still there. We'll be pulling those off soon because Daryl Brooks is about to kind of disappear from the limelight, so we won't really have him anymore. Wait, apparently things are being pushed back, so. All right, so here we go. We can watch what happened to him real quick.
Okay. All right. Thank you.
Let me look at him now. He looks like a little bitch. I wonder what happened to him, or what did he hurt? Did his box fort collapse on him? I mean, I will say it's yeah, I mean it's very short, and now we're into the waiting pattern, which I don't know what this means. I don't think he'll walk in on his own. The judge says hi, yeah. Nope, no sound. He's it's on pause. Yeah, he has a lot of trial experience. A lot more than a lot of us. So, all right, guys, since there's nothing happening there, we're just gonna peace out of that. I mean, we'll watch it later at some point. Do you guys have questions about what we just got done going through? Certainly, you guys got to have some questions. And actually, I don't know who this is. Let me take this call real quick, chat. Oh, sorry about that. Somebody trying to sell something. Oh, never ends. They want you to buy this, buy that, buy this software, buy that software. Do you need loans? It's like, you could buy loans to buy new machines, sir. And I'm like, I'm an attorney. I don't need machines. Nova's asking, if I'm being sued, can my wife divorce me and take all her stuff so when I lose my case, the woman won't be able to collect from me? Well, not all that stuff's going to necessarily be that way. And depending on if it's done to hide from the court case and shield assets, those may not be valid. There's going to be some issues around that. I'd be more worried about settling if your case is looking that bad and get it the right way done. Automata says, oh no, getting on wheels again was Daryl's plan all along. Yes. Oh. Bush says, do you know what being in a wheelchair means while in prison? The dude got an unwanted backdoor entry. Yeah, or he suffered a leg injury and they don't want to give him crutches because they're worried about him using his weapons. So it's not just a booty hole thing. not just the booty hole thing. Be funny, he tries to run people over at slow speed. Brooks heard I was talking shit. Yeah, that's his problem. Bush is saying, can the judge strike testimony from state's witnesses during defense's time if they show evidence proving them lying on the stand? Meaning, if I offer that proof, can they then strike the testimony? Well, they've got to. Sometimes you don't want to strike the testimony. You just want to show that that person lied and let it hang out there. And be like, look, ladies and gentlemen, they lied. We have 100% proof that it happened. Now, you can bring up, like, maybe you can argue for an ending instruction or a curative instruction. Ladies and gentlemen, you have heard this witness tell an untruth. Please don't worry about assessing criminal liability. Just use it to assess the credibility and weight of the testimony they offered. Legal aids for sale. They're listening to you make your own dozer. Would you like to rent or ride a truck, sir? YT refuses to post a message that I have tried to write about wanting to Baker Act, told Karen it had buns to her. You know, I hit him. Yeah, I don't know why. She's like all out of control, just like bop. It was not a shower call, I promise you. I would take the shower call live. Why does he have a hearing anyway? He's got other court cases still, including one of his cases where he ran over his girlfriend at the time, which is that woman he brought into court and tried to fuck with, over with that same car. There's a history. Oh, the hearing's back on. Here we go. All right, we'll switch over to this real quick, chat. We finally broke his through.
Says Daryl Brooks, 21 CF 4596, 21 CF 502 appearances.
Matthew Tarbinson and Shelley Grosso.
4596, 21 CF 502
Oh my God, listen to this lady, how she says things.
appearances.
Matthew Tarbinson and Shelley Grosso appear for the state. Good afternoon.
Grosso.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks appears in person. I appear via Zoom. Good afternoon, Judge.
All right. Good afternoon, everybody.
He's not going this one alone.
Mr. Brooks first got here, my deputies alerted us to the fact that he wanted to speak with Mr. Jones. Given the fact that Mr. Jones is via Zoom and Mr. Brooks is here in person, the way we accommodated that was everyone left the courtroom, including the spectators in the gallery, the person who was here filming for the media, and obviously all the parties and my staff, except for the deputies. For security reasons, of course, they had to stay with Mr. Brooks. So I allowed them to have a conversation. I wasn't paying attention to how much time it was. It might have been, I don't know, 15, 20 minutes. I allowed Mr. Brooks to have that conversation with Mr. Jones. And then after Mr. Jones alerted the lawyers, I think, and my deputies alerted us, we all came back in. Is that correct, Mr. Jones?
Yes, Your Honor. Thank you.
You're welcome. All right, so we are here for, it was supposed to be a motion hearing and a final pretrial on these matters. They are set for trial on Monday, May 6th, so that's just a couple days from now. At our last date on January 18th, the state indicated they thought they would be filing an amended information and an other acts motion. The defense also thought they may have been filing some motions, so we set this for about 90 minutes. I set deadlines for that all motions were to be filed by March 22nd and April 19th for the responses. I will note that nothing has been filed from either side as far as any substantive motions. Motions in limine were filed, I just believe, by the defense, and they appeared to be standard. So there is nothing to proceed on as far as any substantive motions. Do we remain in a trial posture, Mr. Jones?
We do, Judge. And with respect to the motion filings, we were anticipating potentially the state filing, and it would have been a response to their other acts. Presumably, they're not seeking that since they didn't file that. So that's why we had nothing else to file other than our standard motions.
Okay.
God, that guy is on
and nothing from the state?
mode.
Correct. I anticipate filing another acts motion. I thought about it. The prejudice hurdle would be extraordinarily high in this particular case. And
It's a
when I
very
gave
high
it
hurdle given
more
what he's
thought,
done.
the state didn't anticipate using that other acts because of the prejudicial nature of those other acts, unless there was a defense that triggered the high amount of relevancy to those other acts. And I think that would just as likely happen if the door is potentially open by one of those defenses being argued in this particular trial. And so rather than file the motion, if the defense becomes that this is an accident or some sort, then I may raise the issue at that point. So, but I did not file another acts motion. That's correct.
Okay. All right. So we'll deal with those issues if they arise during trial. Maybe they won't. So obviously we have some special issues associated with this case.
That's putting it nicely.
Jury selection is going to be our biggest hurdle. What I have thought, just on my own, and I don't know if the parties have thought about this. I don't know if anybody would think that a court trial would be a preferable way to go to avoid any of those potential issues that would arise with having a jury and trying to seat a jury with a case that this case is not notorious, but certainly Mr. Brooks's other case is notorious. And we certainly will do our best to seat a fair and impartial jury. But that's just off the top of my head. I think that might be the best way, but of course, Mr. Brooks, that is ultimately his decision on whether it would be a court trial or a jury trial. So I just throw that out there. Nobody's requested that at this point. There has been a request for a jury trial, so we will plan on that, but it is just some food for thought, that it may be a way to allow for evidence to be presented without the potential tangential issues that would arise with a jury. So that's just something to think about.
He doesn't know what he's nodding his head to.
In addition to that, if I'm going to go on the assumption at this point that we are having a jury trial, I have not prepared any written information. I will prepare that over the weekend and give it to the parties, and we can certainly talk about it. But I think we have to address it. No one is going to pretend that we're going to introduce Mr. Brooks and no one's going to know who he is. So obviously it's not going to be, one of the standard questions I asked during voir dire is, has anyone heard anything about this case or about this defendant or had any opinion as to anything? That may foreclose us from seating any of the people that we bring in for voir dire right off the bat, because it was a big deal. The Waukesha case was a big deal. So I will prepare something. Do the parties have thoughts? Or do you want to prepare something as well, and we can kind of put something together as far as a preliminary statement to the jurors? I mean, obviously advising them that this needs to be, you will only judge this case on this evidence, and, asking those questions if they can be fair and impartial and put out of their minds anything that they may know about Mr. Brooks. Each side can submit something if they would like. I'm kicking myself that I didn't think to tell everybody to do this ahead of today's date, so we could have worked it out this afternoon rather than doing it on Monday, but that was my error. I probably should have thought of that, and I did not. So if the parties want to do that, they can do that. I will have some language that I work up as well.
She's not even ready.
Other than that, I just talked with a sergeant from the sheriff's department. In the past, Mr. Brooks has been transported directly here and not really held in the jail, even as a waiting position, until he's brought directly to court. And then generally he's whisked away. I don't know what their plan is. I've I've got some concerns that if we're going to be in trial, I don't know what the situation would be in the jail, but I have alerted a sergeant in the sheriff's department to my concerns to make sure that Mr. Brooks is going to be here every morning for trial, that we're not going to end up with him being housed somewhere else. But I don't know that's not something that I get involved in generally. I did just want to put it on someone's radar to make sure that we have no delays when it comes to that. Is there anything that, I think your motions in limine were pretty standard, Mr. Jones. So you've both tried many cases in front of me. Everybody knows generally how I run things and how things work. So I think they're standard motions in limine. So they were along with the rules of how I do things. Does the state have anything they want to specifically address on the record this afternoon?
Your Honor, the only thing that I want to address is I do anticipate filing an amended information. I have for a long time been very clear that if this proceeded to trial, that I would file charges of intimidation based on the calls that were made on particular days. And so I anticipate having a total of 6 charges for intimidation of a victim in the amended information. I will get that filed as soon as possible, but I have explained that both to Attorney Jones. I've explained that to previous counsel numerous times in communications on this case. I don't think that's a surprise to anybody. I think on the charge in the underlying domestic violence case, we are going to be proceeding on amended charge of first-degree recklessly endangering safety rather than second-degree recklessly endangering safety. So we will have those charges amended. And if the court wishes, I can prepare the jury instructions over the weekend, if that helps with regards to the charges.
Okay.
And then my only other question is, would the court prefer having information with both cases joined in a single information or having 2 informations with 2 cases? I can prepare it either way.
That is a CCAP protect issue that is above my pay grade.
Okay.
I think they probably need to be filed in each case. I'm looking at the back of my clerk's head, and she's indicating, yes, that would be better. So separate for the separate cases. Mr. Jones, do you want to be heard as to what Mr. Torbensen's statements or your own issues?
Yeah, let me respond to Mr. Torbensen first, then I have a few things I'd like to address. Mr. Torbensen indicated if it does not resolve with a plea, he would file an amended information and bring all the charges he thinks that he can prove. And that's not news to me, and it's not news to prior counsel. I have requested for Mr. Torbensen, I know I have it in writing somewhere, but I've made a request of him to put his offer in writing because Mr. Brooks wants it in writing in an email, so you could just send it to me one today with that discussion. Mr. Brooks had some issues with potentially discovery at Boscobel. I'm going to provide him written or all paper discovery that I physically can get my hands on and give it to him also Monday, even though we sent it to him back in March. And I'm not saying Mr. Brooks is wrong. I'm sure the institution may have lost it, but we can deal with that. I have it all. I'm prepared. The one request, I only have 2 requests. Number one, I think given the nature of this and the panel and the background, it would make sense if we started maybe at 9 o'clock. I have 2 quick appearances at 8:15 and 8:30 that I'd like to clear off. If we come in at 9, obviously I think if the 3 of us get together and decide how to deal with a joint statement, and I would prefer it to be issued by the court rather than the state or me, I think we could accomplish that in probably about a half an hour's time. The other thing I'm going to make this request, and I don't know how much the court has the authority to do this other than that you can make a request to the jail, but your request would probably be received better than mine, even though I've made inquiries. I know, or at least I've learned now, Mr. Brooks might be moving back and forth to the institution. I understand we can't control that. If at the end of every day of trial, I can have a deputy keep him in the bullpen for some period of time, half an hour, so I can at least meet with him in the bullpen, or if we can break at 4:30, so we can have someone till 5 o'clock, so I can have some time with Mr. Brooks after each day of trial. It may not be needed. I might say, hey, today that we don't need it, but I'd like that little bit of cushion because he's going to be physically removed, and I won't have the opportunity to do that. So maybe we break a little bit earlier than we normally would, so I could have that on days I might need it. Just sort of thinking ahead.
Sure, I think we can accomplish that.
You know, because I want as much communication with Mr. Brooks, obviously, as possible. but I understand I'm bound by the executive, or straight the executive branch and their whims.
Judge, it's probably too late for this as well, but I'm just taking in the size of your courtroom physically, and I'm wondering if there's any chance we could switch courtrooms just for jury selection even, because I imagine we're going to have a rather large panel for jury selection.
What I anticipated doing, and I think it probably is too late to plan a switch now.
Yes, it is.
What I would anticipate is I can get 35 in. It's tight, but we can do it. So we'll have, we can have 35 people in here. And then if we are able to, let's say, seat 8 out of the 35, we will put them back in our jury room and bring a fresh panel of 35 over and do it in that way. I don't have any idea how long this is going to take, given, as I said, the notoriousness of the Waukesha case. So I wouldn't want to guess that one of the bigger courtrooms is going to accommodate it and still doesn't, and have everybody move for those purposes. So I think we just kind of get as many as we can and then start with a new group. So it may take longer than usual. So we may do a couple.
Is it really going to though?
Process of picking a jury in piecemeal fashion. But we should be able to accomplish it in that way. I think if we do run into issues, that may be the best way. So what I'm hearing from everybody is Mr. Torbenson has offered to put together the jury instructions. I appreciate that. And we will all work on what our idea of a statement looks like as far as what to tell the jury about this case, and that it is only this case they are to determine. Not anything else they may have know or heard or think or believe they know or any judgments they've made. And we will question people about that specifically. It's not going to be a general run-of-the-mill, I assume you haven't heard anything about this. You haven't, yeah. So we will take it from there. So everybody's going to bring that statement, and Mr. Torbenson's going to do the jury instructions. Is there anything more from the defense?
Yeah, and Judge, scheduled meeting with Mr. Brooks tomorrow at 2:30. Apparently that's not going to occur because he won't be at the jail. I'm efforting to get a meeting with him at his institution when we.
I don't know that for sure.
Well, Mr. Brooks is fairly confident of that. Either way, I've got the one set up at the jail. I'm going to try and set up the one at the institution, and hopefully, one of them occurs.
Okay.
And if he can be brought over at 8 a.m. even, I will try and get down there. I mean, I'm just saying, once he's in your bullpen, I think that's a place that makes it easier for me to get to him. But we'll stay in communication and do what we can, I guess.
Okay. All right. Anything further from the state?
The only thing I want to add is that
Yep. We just got snubbed. Stream. Oh, it came back. Okay.
Anything further from the state?
the only thing I want to add is that I did tell the court and counsel and chambers I have a homicide case.
What channel is this on here?
We'll stay in communication and do what we can, I guess.
Okay. All right.
The court and counsel and chambers, I have a homicide case.
What, the microphone? The internet. I can't hear. What? The internet? Oh, okay. So it's just the internet's down.
Clyde did this. I've had enough of this. Like, let's just get this going. Come on. Like, you weren't so local. We rest.
Acting.
Oh,
Yes.
you're muted. I don't know if you can hear me.
Your mute is on.
Oh, thank you.
You're welcome.
I automatically ended up muted, but Mr. Brooks pointed out to me that I could unmute. So now we can hear you and you can hear us.
We're back.
All right. So
The last thing I heard was Mr. Torbenson saying he has a homicide trial, has an emergency stay. and then he froze.
Right.
I think it's unlikely for the stay to be lifted, and this should be the case that can go on Monday.
Okay. All right. All right, then I think we just stand ready to go on Monday, barring something else happening. Mr. Brooks, I don't know where you're going to be, but I look forward to seeing you on Monday. Mr. Jones said.
All right, so Darrell Brooks going to trial on Monday. Interesting. Brooks doing tech for the judge, yeah. So this is the other case, the case where he was terrorizing his baby mom, the one he had raped as a juvenile. So that'll be interesting. And we won't be able to cover that because we'll be in the middle of Karen Reed, but if it's being broadcasted, guys, I will watch. We'll save it, and then we can watch it later. That will be a fun time. HM says, why doesn't the prosecution offer a favorable plea deal? Maybe Darrell Brooks doesn't want one. I mean, that's part of the issue. He's an asshole. Maybe he doesn't want one. Maybe they've offered it, and he's like, nope, don't want it. Don't want it. Okay. And guys, I have my window open. The big dog we've been watching, his owners are coming any minute. And I just want to make sure I'm ready and don't leave them waiting in the rain because we have them coming very shortly. So that is the plan. Is this trial a waste of time? Yeah, he assaulted her and ran her over the car. Makva saying, what's the purpose of another trial? Well, he attacked his girlfriend and tried to run over and kill her. You know, they have the right to seek justice there, and as they should seek justice. He should be held accountable for what he's done. So, besides, we might get some Darrell Brooks antics, which, don't lie, y'all want to see, as do I. This time, though, he's been represented by counsel, so that changes things up for us. That changes things up just a little bit. So, it creates a different situation. Where is... Where is my, trial playlist? And I'm trying to have saved up. Oh, yeah, here we go. All right, because I need to go through. Guys, we've got a couple of backup trials we've been putting together. I've been putting together a catalog of some trials. Just so we have them. Including a couple of the... there's a trial involving some of the young thug guys who just got done with their stuff. I mean, there's all kinds of neat ones out here we can hold on to. We've got one of a police shooting out in Connecticut where the cop got charged with murder. We've got a officer out here in Ohio who got charged with assault. There's a lot of good ones we can use. So we'll put this in that folder of backups to watch after we clear some stuff out, and we can make up time with it. Hold on here. Bridget and Robinson. Sorry, guys. So I think we're I think we're all kind of caught up here as far as we are need to be on everything. Just double checking I didn't miss anything. All right. No, we are all set. We are all set here. I'm going to send you a pretty short video of Columbus PD. Yeah, those are good. Those are always good. Maybe do Daryl Brooks live and catch up on Karen Reed on the weekend. Yeah, or maybe we'll do Daryl Brooks on the weekend. I mean, Karen Reed's only going to be so much anyway. Watch him try to drop his attorney right before trial. I don't. Doesn't sound like that's going to be an issue. Sounds like him and his attorney get along. So, something to think about. So yeah, guys, this was a snoozer of a day for Karen Reed. Eventually, it'll get better at some point, right? Right? We'll get to the actual evidence. So, I'm looking forward to it. I'm hoping we find more out. Like I said, if I'm wrong and it turns out Karen Reed is guilty, fine. If I'm wrong and it turns out Turtle Boy was right, cool. I'm willing to be wrong either way. It just, I want to get to a resolution of this and like, let's get to the heart of the problem. We haven't done that yet. So, calling it hung jury already. Well, we'll see. We'll see. I don't think it'll be hung jury. So yeah, there are a lot of people want to watch Daryl Brooks. I don't disagree with you. You know, we may try it for a day or two and see what happens. And if a lot of people watch, then we'll keep going. If not, we'll pick it up later. So, I did want to say, I think with that said, though, we're all caught up. We are done ski. I think he's innocent. I just don't think the state can prove it. Blacksmithing and models of planes. That's part of their problem here is they can't prove it. So that's what I think the biggest issue is. So as far as tonight, guys, I think there's a YouTuber out there who's doing a Richard Allen fundraising stream. He's invited me on. I think it's Case Closed with CJ. I'll put stuff up in locals and on YouTube if I have more information about it. Tonight, I have to pick up 2.0 from the airport. And that's late at night, so I don't know what we're doing right now. A lot of this is going to be kind of playing things by ear. And like I said, I've got to get ready to have our dog we're watching picked up. And I might come back on for a little bit. But for right this minute, I don't know what's planned. We'll have to kind of wing it. But I'll let you guys know tonight. So in the meantime, take care, everybody. And you guys can hear me, right? Because I try to do this the right way. Yes, 2.0 is updating your Fed handlers on how things went. Good, you can hear me. Good. Yeah, what time do I have to be at the airport? That's kind of important. I know that. Yep, I have to be there at 9:30. So I can get back and we may do something later tonight, guys. There's someone behind me. Good. End my existence. All right, guys. So the person picking up their dog is here. I will see you guys around. And yeah, remember, just because she did it doesn't mean she's guilty. Take care, everybody. Good night, chat.